Good afternoon. All right, this is case number 22 CR 89, State of Ohio versus Robert D. Boline. You're Robert Boline, appearing on the screen marked Robert Boline.
Yes, sir.
All right, this is a pre-trial being conducted by Zoom. The defendant is appearing by Zoom. His attorney is Christian Malone, appearing from his office. Appearing from the prosecutor's office is prosecuting attorney Collins. Defendant's charged in a multi-count indictment with looks like 4 co-defendants. He's charging counts 1 and 2, 12 and 13. It's a final pretrial. We have trial set for the 24th. Now, has discovery been completed by both sides?
The discovery
Yes,
has been completed, Your Honor, and we have reached a plea agreement in this case.
Okay.
It just needs set for a plea. Mr. Malone and Mr. Boline aren't close to each other, so they need to meet up so that they can sign the plea form and then get it back to my office.
Okay. Well, I think what we'll do is we'll do that one in person. You want to go ahead and set it now?
Yes, Your Honor. We'd ask if possible if that could be after May 2nd. He has a pretrial in Madison County on May 2nd. He'd like to attend that before that.
Well, the trial is set for April 24th. So,
I would move to vacate the trial. I can do that in writing if necessary.
well, the agreement, if we have a plea agreement, the deal is we get the pleas in 14 days ahead of the trial date. Now, this case has been pending since February. And what's he got in Madison County? Bring me the count. Okay, got it.
It's a F3 vehicular assault, Your Honor.
Okay.
Your Honor, even if we want to, the court wants to do this in person, the plea in person, if they could set it for a sentencing hearing, the state would have no objection to that. I understand what Mr. Malone's trying to do.
Okay. Well, what we'll do is we need to plead before then, and then we can defer sentencing.
Yes.
Right. That's perfectly fine, Your Honor. Thank you.
Okay. So. I have an appointment in. Oh, I must be.
A long time ago.
Long late. Yeah. Okay.
Yeah.
Oh, okay. I forgot about that. All right.
Monday we're good.
Let's see. We have nothing on Monday. Well, we do have the James Brown trial. I'm going to talk to Mr. Armstrong about that. That's not been officially continued, but it is going to be vacated. And we're going to set that for another hearing and a trial. So how about Monday? Are you available Monday, Mr. Malone? Anytime?
In the afternoon, Your Honor. In the morning, it looks like I have some hearings.
How about 2 o'clock?
That'd be perfectly fine.
All right. So you'll need to be here at 2 o'clock on Monday the 10th, Mr. Boline. And then we'll schedule a sentencing. When did you say the hearing is in Madison?
It's May the 2nd. I can't remember what time of day that was.
Okay. Well, I think our sentencing would be the 3rd, so we would go ahead and set it for the sentencing on the 3rd at 9 a.m. But we'll wait until we get the plea before we do that.
All right.
All right, so Mr. Boline, you need to be here next Monday, 2 o'clock, in the courtroom. Okay.
Yes, sir.
All right, thank you.
Thank you.
Thank you.
All right. CR 42, State of Ohio versus John Carl Nicely. Mr. Nicely is appearing from the jail by Zoom. His attorney is Dennis Kirk. He is present from his office, and representing the state is prosecuting attorney Collins. The defendant is charged with violating a protection order, a 5th-degree felony. I believe we have a trial date coming up sometime later this month. And I have received a plea form, Mr. Nicely, which indicates that you're going to withdraw your not guilty plea and plead guilty to the charge. I'm going to hold this up to the camera and ask you if you recognize that page.
I do, Your Honor.
Okay. Hold on here a second. I want to speak to Mr. Armentrout. He's here in the courtroom. Bill, did you get a hold of Mr. Brown?
Who?
James Brown?
No, sir.
All right. What I'm going to do is this. We're going to vacate the trial Monday. It's going to be a pre-trial, and he needs to appear. And if there's no plea, then it'll be set for trial in a couple of weeks, and that will be it. There won't be any more dealing.
When we're gonna set it?
It's scheduled for Monday at 8 a.m. So
Oh, for pre-trial.
yeah, so we'll set it for 8:30. Just tell him to be here on time, and we'll do it at 8:30.
I've got 1 o'clock, I've got Dylan Harmon, he's not in jail,
Okay.
and we've got an agreement worked out, just we'll see him today. Our other two are till 2:30.
All right. Okay. Well, we probably won't get to him until 2 o'clock anyway.
Okay.
All right. All right. Mr. Collins, I was just talking to Mr. Armentrout. I'm going to vacate the trial Monday on Mr. Brown, but it's going to be a pre-trial. So it's
Okay.
still on. He needs to appear. That'll be the time that we'll determine if there's agreement or if there's a trial. And if I reschedule it for trial, there will be a trial. So
Is that at 8 a.m. on Monday?
you can come in at 8:30.
Okay,
Yeah. All
thank
right.
you.
Okay, now, Mr. Nicely, sorry for that interruption, but I needed to talk to Mr. Armentrout. Now, on this agreement that I just showed you on page 3, there is a sentence about a third of the way down the page. It says, "I enter this plea voluntarily," and immediately below that, there's a signature of defendant, and a line above that with what appears to be me, John Nicely. I'm going to hold that up to the camera and ask you if that is, in fact, your signature.
Yes, Your Honor, it is.
When did you sign this agreement, Mr. Nicely?
Around 11 o'clock this morning.
And before you signed it, did you go over it with your attorney and have him explain everything to you?
Yes, he did.
And when you signed this, did you understand it's an agreement to plead guilty, which means there won't be a trial, and the next step in your case would be a sentencing?
Yes, Your Honor.
And did you have enough time to fully consider this matter before making this decision?
I did.
Do you feel that you've been rushed or pressured in any way into signing it?
No, sir.
Did you sign it voluntarily?
Yes, Your Honor.
All right. Now, this agreement states on page 1 that you're going to withdraw your not guilty plea to the charge of violating a protection order or consent agreement and plead guilty to that offense, which is under Ohio Revised Code 2919.27A1, fifth degree felony. Further states that you understand that the maximum penalty for that could be 12 months in prison, the minimum is 6 months. There's a fine of $2,500 available. Do you understand that?
Yes, Your Honor.
Now, are you facing any felony charges anywhere else, Mr. Nicely?
No, sir.
Are you currently on probation, community control, parole, or post-release control for a felony?
No, sir.
Right now, under the law, if you are convicted of this offense and sentenced to prison, once you complete that prison term, it is possible the adult parole authority may, at their option, put you under post-release control supervision for a period of up to 2 years. They don't have to, but it'll be up to them. If they decide to do it, they will. And if they do, then you'll be supervised under those terms that they set by a parole officer. And if they determine during that period of time that you have not complied with those conditions, they could return you to prison to make you serve an additional period of up to half of the term of imprisonment that was imposed for one or more violations. But should you be convicted of a new felony while under post-release control, then in addition to whatever sentence could be imposed by the judge in that case, that judge could also sentence you for committing that offense while under post-release control in this case to an additional period of a year, or whatever time is left on that period of post-release control, whichever is greater. And if that occurs, that must be served consecutively the sentence in the new case. Do you understand that?
I do, Your Honor.
Now, under the law, it's not a mandatory prison offense, so I could impose what's called community control, which means you'd be supervised by a probation officer for a period of up to 5 years under the terms set by the court. And if during that period of time probation felt that you were non-compliant, they would file a written notice of that with the court, serve a copy on you. There would be a hearing. You'd be entitled to have an attorney at that hearing, and if the outcome of the hearing was that you'd failed to comply, then at that time the court could revoke your community control and then sentence you to 12 months and fine you $2,500. Do you understand that?
I do, Your Honor.
All right, now the charge alleges in count 1 that on or about June 28, 2022 in Highland County, Ohio, you did recklessly violate a term of protection order or consent agreement approved pursuant to ORC section 2920.26 or ORC section 3113.31 in Clinton County Common Pleas Court, case number 180000029 on February 7, 2018. and that the said John Carl Nicely had previously been convicted of violating a protection order consent agreement in Hillsborough Municipal Court, case number CRB 1800172 on April 26, 2018, in violation of Section 2919.27A1 of the Ohio Revised Code. So that is the offense that you're charged with. Now, do you understand what the state has accused you of having done, when, where, and how they allege that you did it?
I do, Your Honor.
And have you discussed the nature of the charge, the evidence in the case, the possible legal issues in the case, possible defenses you can try to raise at trial, the possible outcomes of a trial with your attorney?
Yes,
Are you satisfied with his advice and confidence in this matter?
I am.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Has anyone threatened you to make you plead guilty here today?
No, Your Honor.
Now, on page 2, there's a couple of lines that are printed in bold and underlined, and then the last sentence of that is stricken out with initials DK and JK, which I believe is your attorney and you. Is that correct?
Yes, Your Honor.
All right. And so what had been stricken out then, the rest of it reads as follows. Defendant shall enter a plea of guilty to the indictment. State and defense jointly recommend 9 months incarceration. Is that your understanding of the agreement?
It is, Your Honor.
And has anyone promised you anything other than that to get you to plead guilty here today?
No, sir.
Now, under the law, the matter of sentence is up to the judge, not the parties. And so even though there's an agreement by both sides to recommend the sentence, the court is not required to follow that. So if you plead guilty, once I've heard all the information submitted, if I decide that's not the correct sentence, I can sentence you to any sentence that's permitted by law, including a maximum of 12 months in prison. Do you understand that?
I do.
And has the state consulted with the victim regarding this disposition?
Yes, Your Honor, and she's actually on in the Zoom hearing.
Oh, okay. All right, so she has consented to this agreement?
Yes.
Okay. Now, do you hold any license or certification from any state agency, Mr. Nicely, that regulates any occupation or profession?
No.
Now, you have certain constitutional rights you must understand before I can accept a guilty plea. First, you have a right to have counsel. Mr. Kirk was appointed to represent you. Now, the appointment wasn't simply to work the case out, but to provide any defense that could be available to you under the law that you would like him to provide. So if you decide that you do not want to do this, that you would rather defend the charge, he will continue to represent you, provide you legal representation, including representing you at trial, if that's what you would like. Do you understand that?
I do.
All right, now under the Constitution, Mr. Nicely, you have a right to have a jury trial on this charge in which 12 people would be selected from a group of citizens that live in Highland County that are summoned for jury duty on your trial date. Once they are selected, the evidence would be presented, and then they would be instructed on the law by the judge. Then that jury of 12 people would decide by unanimous verdict, meaning all 12 of them would have to agree, on whether the state proved the charge. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, then you can waive or give up in writing your right to have a jury trial. In that case, you would have what's called a court or bench trial, meaning it would be the judge would hear the evidence instead of a jury. The judge would apply the law, and the judge would decide whether or not the state proved your guilt. Do you understand that?
I do.
Right now, under the Constitution, you have a right to confront the witnesses against you in open court and to cross-examine them through your attorney. What that means is that the witnesses against you have to come into court and testify in front of you and your attorney and anyone else that may be present. After the prosecutor is done asking questions, your attorney asks questions. That's called cross-examination. And the purpose of that is to try to bring out evidence that would help your side of the case. Do you understand that?
Yes, Your Honor.
All right, now under the Constitution, you have a right to use the power of this court to compel or force witnesses to come to court to testify for you, just like the state. So if you have witnesses you're not certain are going to come in voluntarily, at your request, the court issues a court order. It's called a subpoena. And that forces those people to come to court to be available to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are forced to come to court to testify against you. Do you understand that?
Yes, Your Honor.
Right now, under the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't. It's your decision. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time, and no one's even allowed to comment about it except in one situation, and that is if there's a jury trial and you do not testify, the judge instructs the jury that because that is your right, they cannot consider it for any purpose. Do you understand that?
I do.
Right now, Mr. Nicely, under the Constitution, you have a presumption of innocence. That means you're presumed innocent till proven guilty by the state of Ohio in every essential element of the offense charged. So the burden of proof isn't on you to try to prove that you're not guilty of this charge simply because you've been accused. In fact, under the law, you're not required to present any evidence at all. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state to prove your guilt by proof beyond a reasonable doubt on every element of the offense charged, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, sir.
And I need to pause at this point, do something I should have done at the beginning. Mr. Kirk, you and your client are both in agreement that this matter can be conducted remotely by Zoom rather than in-person appearance in the courtroom.
Yes, Your Honor.
And you're all right with that, Mr. Nicely?
Yes, I am, Your Honor.
All right, thank you. Now, if at any time you need to talk to Mr. Kirk, since you're not here, if you have any questions or anything you'd like to talk with him, just tell me, and I can put you and him into a breakout room where it'll be just the two of you on the screen. The deputy will step out so that you can have a private conversation with him if you need to, okay?
All right, thank you.
All right, thank you. All right, now, originally, Mr. Nicely, there was a not guilty plea entered, which denied the allegations in this charge and denied that you committed any crime and exercised all the rights I have just described. Now, if you change your plea from not guilty to guilty, that is the opposite of the not guilty plea. The guilty plea admits the allegations in the indictment, admits that they're a crime, admits that you're the one who committed that crime. And that plea waives, gives up all of the rights that I've just described for you today, except your right to have an attorney. You always have a right to have an attorney no matter what your plea. But without exception, your plea of guilty waives, gives up your right to a jury or court trial. Waives, gives up your right to confront witnesses against you and to cross-examine them through your attorney. Waives, gives up your right to use the power of the court to compel or force witnesses to come to court to testify for you, the same as the state. Waives, gives up your privilege against self-incrimination because if you say you're guilty, that's what's used to find you guilty. It waives, gives up your presumption of innocence because if you say you're guilty, then the state doesn't have to prove you're guilty. It also subjects you to being sentenced immediately by the court. And finally, it waives, gives up any right to file an appeal you think you may have had up to this point in the case. Now, if you are sentenced to the maximum sentence or under other limited circumstances, you can file an appeal. Any appeal would have to be filed within 30 days of your sentencing entry being filed. You understand all of that?
Yes, Your Honor, I do.
And are you a U.S. citizen, Mr. Nicely?
I am.
Now, do you have any questions about the charge and the possible penalties?
No, sir.
You understand it?
I do.
Any questions about the plea agreement?
No, sir, I don't.
You understand it?
I do.
Any questions about the constitutional rights I've explained?
No, sir.
You understand those?
Yes, Your Honor.
You have any questions about the plea of guilty, what it means, what will happen if you enter that plea here today?
No.
You understand that?
I do.
Is there anything you would like to speak with your attorney about before we go any further?
On this case, is that what you're saying?
Yeah.
Well, this would be my second violation on this charge, or on this order, and the first one was simply the fact that I was not aware that my daughters were on the protection order to begin with, because I'm the one that requested an additional 3 years when the magistrate only requested 2 years. And I did 180 days for saying I love you to my daughter on a text message, and I was not aware that they was part of the order, and the fact that if I knew they was on there, I wouldn't have extended it another 3 years. And
well, I think what you're talking about is maybe something you need to discuss with your attorney, because you know, if you're telling me that you don't think you're guilty, then we're not.
No, I'm saying I'm guilty. I was just saying, the nature of how.
Okay,
this
well, then that's
played out.
something. That's not a question. That's something. If you want to make an explanation when we get to the point, if you are found guilty, and you and your attorney can make that point. But as far as what the plea agreement is, I'm concerned, or I asked, do you have any
I'm
questions?
fine. No, I have no questions.
Okay. And so, is it your decision that you want to go forward and plead guilty according to the terms of this agreement?
Yes, Your Honor.
Okay. All right. Then, as to the charge, which alleges that on or about June 28, 2022 in Highland County, Ohio, you did recklessly violate a term of a protection order consent agreement approved pursuant to ORC 2920.26 or ORC 3113.31 in Clinton County Common Pleas Court, case number 180000029 on February 7, 2018. And the said John Carl Nicely having previously been convicted of violating a protection order consent agreement in Hillsborough Municipal Court, case number CRB 1800172 on April 26, 2018, in violation of section 2919.27A1 of the Ohio Revised Code, which is the charge of violating a protection order or consent agreement a fifth-degree felony carrying a possible prison term of 6 to 12 months, and a fine of $2,500. How do you plead?
Guilty.
All right, the court finds that on this day in open court, defendant was advised of all his constitutional rights, made a knowing, intelligent, and voluntary waiver of the same pursuant to criminal 11. Pleas accepted and order filed. The defendant is found guilty of the charge as set forth in the indictment. All right, there's a stipulated sentence. There's been a previous conviction, sentence recommendation, I should say. So the court is going to go ahead and proceed with sentencing. Now, anything from the state?
Your Honor, we would ask the court to follow the joint recommendation. Would notice that this is his second violation for, or violating, second conviction for violating a protection order, this one being the felony. We would also note that he has other felony convictions other than this charge. He was convicted of OVI in 2014 and did a period of time in prison, improper handling of a firearm in a motor vehicle in 2018. And a failure to appear in 2019, those two charges out of Clinton County. So based on his prior criminal history as well as the nature of this offense, we would ask the court to follow the joint recommendation and sentence the defendant to a term of 9 months incarceration.
All right, Mr. Kirk, on behalf of the defendant.
Thank you, Your Honor. Would ask court to follow the plea agreement. This incident stems from back in June of 2022, just now being brought before the court. The incident was a Facebook message that was sent. In review of that Facebook message, there were no threats in the message itself. He did not go in person or take a weapon or do anything to threaten violence. He basically a technical violation in the sense that he made contact with her and asked about his children in common with her, and that was obviously a violation of the protection order, as they are protected on the order as well. So he went about it the wrong way, but he's owning up to it here and wishes to resolve this matter and ask the court to follow the plea agreement.
All right, Mr. Nicely, now that it's your opportunity, if you'd like to say anything regarding the matter of sentence, you may do so at this time.
Okay, yeah, but I'm just going to finish elaborating on what I was speaking on to earlier about how when the order was made, it was made for 2 years, and I asked Magistrate Rollins to grant an extra 3 years due to the simple fact that I did not know my kids were going to be part of that order, or I wouldn't even have had that order extended for another period of 3 years. And it's been 5 years, and like Mr. Kurt said, I went about the wrong way. I figured she would be more civil and understanding by now, and see that what she is doing is not right for her kids, and she has not only took them from me for whatever power and control issues that she does have, she has taken them from my whole family and blocked them. Even their oldest sister, Carly Rhodes, they have no contact with them, and it's all for power and control issues that she has. And quite frankly, if I have to go to prison just for trying to, reach out to my kids, and I understand it was a violation on an order, so be it, I guess. But I'm just trying to see my kids and establish that relationship with them at this time is all I'm trying to do.
All right. Did the victim wish to address the court, Mrs. Collins?
Not that I'm aware of, but she may after that. She's unmuted herself. If you could turn your camera on.
If you'd like to make a statement, Miss, what is her name, Miss Kuipers?
Yes.
Yes.
Did you wish to make a statement?
Yeah. We do have a protection, the civil protection order for 5 years. He was very aware in the court. Ms. Rollins was very thorough on that. When we went to court, there's a right way and a wrong way to do things, and he obviously went about things the wrong way. Me and my girls, we had a couple years of peace where we had no contact, and that was broken this last summer, and there has been a lot of distress, in our family because of that. Both the girls have been diagnosed with PTSD because of this. And even though it wasn't violent and it was only through Facebook, there is that fear of him. He has come here with a gun and he has made threats. And all three of us have that fear that that's going to happen again. like peace is a huge thing, and he has broken that, and we have cut all contact with everybody because that's what's best for us, for all three of us. And, the girls are of age and they're old enough to make those decisions too. And as a family, we stand united.
All right, thank you. And by the way, Ms. Collins, is the previous conviction, was that of the same protection order?
I believe so, Your Honor.
All right. All right, well, I also would note, Mr. Nicely, looking at the discovery, that you had another violation of a protection order back in 2003 in this county. I don't know what anything more other than what I see on the discovery. And then this 2018, you had the previous conviction on this case, and now this one. And I understand your frustration about your children. That's something that has to be done, through court. If you want to do something about that in the future, while they're still under the age of 18. But contacting her is not the way to do that. And anytime I see a violation of protection order, it's always a concern to the court, because domestic violence is such a serious thing. And when you have a second violation of the same order, that's concerning too. And so, to your credit, there was no threat of violence, but it violated the order. And unfortunately, there's too many people out there that when we have these things, they seem to think that, it's just a piece of paper and they don't have to listen. And they can do whatever they want, but that's not the case. It's a court order, and it's something that this court takes seriously. So, based upon that, the court finds that it's appropriate for the defendant to receive a sentence, and it's therefore ordered that he be sentenced to the Correction Reception Center at Orient, Ohio, for a period of 9 months. And according to this, there was the defendant was incarcerated from 2/7/23 to 3/7, 29 days, and then, but that was applied to. Okay, yeah, that did apply here, and then also was given credit for March the 7th until March the 28th, 22 days, which would be 51 days, and then according to this record, you're serving a sentence out of juvenile court for 60 days since March 28th. So there's no credit for that time.
Your Honor.
Yes.
I represented him in that case, and the entry in the juvenile matter reads that it would be concurrent time to what he's doing now in the felony case.
Oh, okay. All right, then he would get credit for that, so that'd be another 7 days, or 3 days in March, and 5 days a day would be 8 more days, so that would be 59 days. Okay. So you get 59 days of credit, Mr. Nicely, against that sentence. Now, upon completion of this sentence, it is possible that the Adult Parole Authority will put you under post-release control supervision for a period of up to 2 years. They don't have to, but they may. If they do, you'll be supervised on the terms they set, and if during that period of time you fail to comply, they can return you to prison to make you serve an additional period of up to half of your prison term, which would be 4.5 months for one or more violations. But if you commit a new felony, then in addition to whatever sentence the judge in the new case imposes upon you, that judge could also sentence you for committing that offense while under post-release control in this case to an additional period of 1 year or whatever time is left on that period of post-release control, whichever is greater. And if that occurs, that must be served consecutively to the sentence in the new case. You're also ordered to pay the court costs, which judgment, grant, and execution is ordered. And if you don't do that or make payment arrangements and pay in accordance with that, then the clerk of courts could collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then upon completion of your prison term, not while you're in prison, but once you get out of prison, you can do community service in this county and be given credit for each hour you work in an hourly rate set by the court, and each hour you work will reduce your judgment by that amount until paid in full. All right. Is there anything further from counsel?
No, Your Honor.
All right. You're remanded custody then, Mr. Nicely.
Thank you.
All right. Jacob McComas. 22 CR 231, State of Ohio versus Jacob McComas. You're Jacob McComas appearing on the screen. It says Jacob McComas.
Yes.
All right. This hearing is being conducted by Zoom. His attorney is Sarah Barger, who is appearing by Zoom as well. Representing the state is Prosecuting Attorney Collins. Now, this is set for a plea on an intervention in lieu. Ms. Barger, are you and your client both in agreement that this matter be conducted by Zoom rather than an in-person appearance before the court?
Yes.
Yes.
And you're in agreement with that, Mr. McComas?
Yes, sir.
All right. Now, I do have some faxes here from Southern. It's a little bit hard to read. Let me see if I can find this here. Okay, Southern Hope Recovery Center out of Ironton. And so that's where you are. Are you there currently? Or are you? Is that outpatient or inpatient?
Inpatient.
Inpatient. Is that where you are today? Okay.
Yes, sir.
All right. All right. So that is a certified facility. I'm familiar with them. All right. Now, I have been presented then with a plea of guilty form and admission into the intervention in lieu of conviction program. Now, I'm going to hold this up to the camera, Mr. McComas. Well, wait a minute. All I have here are the stipulated questions.
No, we gave the plea form, Your Honor.
Oh, we do?
They were paper clipped together.
All right, wait a minute. Oh, there it is. Okay. All right. Okay, I'm going to hold this up to the camera then, Mr. McComas. That has your case number and name on it, and the plea is that. And I want to make sure you recognize that form.
Yep. Yes,
Right.
Your Honor.
And on page 3, there is a sentence that reads, "I enter this plea voluntarily," right at the very top. Below that is a signature for defendant. It appears to be Jake McComas, 32723. I'm going to hold that up to the camera. Is that your signature there?
Yes, Your Honor.
And you signed this on the 27th of last month?
Yes, Your Honor.
Now, when you signed this, did you understand it was an agreement to plead guilty to the charge, meaning there's not going to be a trial?
Yes, Your Honor.
And did you go over this, or did you talk to your attorney about this before you signed it to make sure you understood what the agreement was?
I sure did, Your Honor.
And do you feel you had enough time to fully consider this matter before making this decision?
Yep.
And do you still wish to go forward with that plea today since it's a week later?
Yes, Your Honor.
All right. Now, under the law, Mr. McComas, normally when somebody pleads guilty, they're found guilty. And then the next step is a sentencing hearing. And that sentence could be, in this case, for 2 F5s, it could be 6 to 12 months on each, a fine of $2,500, and a license suspension of 6 months to 5 years on count 4. And then it could be probation or any combination of those. Now, under the law, there is a provision that people that are convicted of certain offenses, if those offenses were committed because of substantial influence of a result of substance use disorder and substance abuse, then they can enter into a treatment program, which you've done. And if they comply with that treatment program and also have to remain drug and alcohol free for 1 year and comply with conditions of supervision that the probation department, that the court has for these types of programs, then at the conclusion of that, the charge is dismissed, because if you go into this plan, the court doesn't find you guilty, because until I've found you guilty and actually imposed a sentence, there's not a felony conviction, even though there's a plea of guilty in the file, in the court file. And somebody looked at it and said, well, he pled guilty, he's got a felony record. Not yet, because until there's a sentence imposed, there is no felony conviction. And so this is an opportunity for you to comply with your treatment plan and get clean and stay clean, and to comply with supervision. Now, the conditions of supervision are not as extensive or as stringent as ones for people who have been convicted of a felony, but they're there. And it can go for up to 5 years. I start out at 2 because that's I think that it takes about 2 years to see rather than 5. It can be extended in some cases depending on what's going on. So that's what's required. Now, the advantage of that is this. If you complete the program successfully and you comply with the conditions, then the court will dismiss the charge when it's notified of your completion by the probation department and the prosecutor's office. And then I set the matter for a hearing. And so the case is dismissed even though you pled guilty. And then after that, unless you get charged with another felony before that happens, at the sealing hearing, I will order the case records to be sealed. And that means they'll no longer be accessible to anybody in the public or law enforcement, except in certain circumstances. So that's the advantage to you. And then that means that in the future, once you've completed the program and the case is sealed, you can tell people that you do not have a felony conviction. And that's the big advantage to you in this program. Now, the disadvantage is this. You don't get to try the program, see how it goes, and then if it doesn't work out, come back and say, okay, I'd like to have a trial now. It's not the way it works. If you want a trial, this is the time you have to do that. And that's why we have to go through this explanation. Now, if you're put into this program, which is, at this point it's my intent to do that, the only way that it would you would be convicted is if the probation department filed a notice of that with the court and alleged what you did was a violation. Then we would have a hearing, and you would have an attorney at that hearing. And then if the court found that you had failed to comply, then the court could terminate you from the program and then sentence you. Now, at that time, the sentence would not necessarily be a prison term. It could be, but it wouldn't have to be. It could still be a fine or driving suspension. It could also be community control. Community control also can be for a maximum of 5 years. I usually set it at 3. And that's under a different set of conditions that are more strict, and there are more of them. But it works the same way as this plan does, in that if you are under supervision and you don't comply, then the probation department has to file a written notice of that with the court and serve a copy on you. There's a hearing at which you can contest those allegations, and if the outcome of the hearing is that you fail to comply, then at that time the court will revoke your community community control and then sentence you to prison for 6 to 12 months and fine you $2,500. Now, do you understand that?
Yes, Your Honor.
All right. Now, the agreement says you're going to plead guilty to count 1, which is breaking and entering under 2911.13a, 5th degree felony, and count 4, aggravated possession of methamphetamine under 2925.11 and F5. And as I've mentioned already, each of those have the same possible prison term of 6 to 12 months, the same fine of $2,500, and then count 4 being a drug offense, there's a possibility of a license suspension of 6 months to 5 years. And if you are ever sentenced to prison, if you're found guilty and sentenced, those sentences could be ordered to be served consecutively for a total of maximum of 24 months and a total fine of $5,000, in addition to the suspension of driving privileges. Now, do you understand all that?
Yes, Your Honor.
And are you facing any felony charges anywhere else?
No, Your Honor.
Are you on probation, community control, parole, or post-release control for a felony?
No, Your Honor.
All right. Now, the charges in this case in count 1 read that on or about January 13, 2022, in this county, that you and Zindal Russell and you did knowingly by force, stealth, or deception trespass in an unoccupied structure, to wit 10709 North Shore Drive, with purpose to commit therein a theft offense as defined in ORC 2913.02A1 or a felony. So that's the B&E charge of the 5th degree felony. Count 4 alleges on or about that same date in this county you knowingly obtained, possessed, or used Schedule 2 controlled substance methamphetamine. So that's also the 5th degree felony. Now, Mr. McComas, do you understand what it is the state has charged you with, what they said, when, where, and how they alleged that you did it?
Yes, Your Honor.
And have you discussed the nature of the charges, the evidence in the case, the possible legal issues in the case, possible defenses you might try to raise at trial, and possible outcomes of a trial with your attorney?
Yes, Your Honor.
Are you satisfied with his advice and competence in this, or her advice and competence in this matter?
Yes, Your Honor.
Okay. Now, and I'm not sure if I asked you at the beginning, but you and your attorney are both in agreement this matter will be conducted by Zoom.
Yes.
All right. So if at any time you need to speak with her, you let me know, and I can put you into a breakout room, okay?
All right, Your Honor.
All right. Now, are you under the influence of any types of drugs or alcohol at this time?
No, Your Honor. I'm actually 90 days clean.
All right. Have any threats been made to get you to plead guilty?
Nope.
Other than the agreement that you enter a plea guilty to count 1 and 4, and the state dismiss the other 2 counts, and you be granted intervention in lieu of a conviction and agree to cooperate with a co-defendant, make restitution. That's on page 2 of the agreement. Have you been promised anything other than that?
Not that I know of, Your Honor.
Okay. And Ms. Collins, did you consult with the victim of the count 1 regarding this matter?
Yes, Your Honor. We spoke with her clear back on February the 15th,
All right.
and she approved this and also advised there's no restitution.
Okay. There is no restitution?
No.
All right. Now, do you hold any license or certification from any state governmental agency that supervises any occupation or profession in this state?
No, Your Honor.
All right, now you have certain constitutional rights you must understand before I can accept this plea. First, you have a right to have counsel. Ms. Bargo's appointed to represent you. That wasn't simply to work the case out, but to provide any defense that might be available to you under the law that you would wish her to provide. So if you decide you do not want to do this, that you would rather defend against the case, she will continue to represent you, including a trial, if that's what you want. Do you understand that?
Yes, Your Honor.
All right, now under the Constitution, you have a right to have a jury trial in this matter, in which 12 people would be selected from a group of citizens that live in this county that are selected for jury duty, or summoned for jury duty on your trial date. After 12 of those folks are seated, the evidence will be presented, they'd be instructed on the law. And then that jury would have to decide by unanimous verdict, meaning all 12 of them would have to agree as to whether the state proved your guilt on either or both charges. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive, which means you give up in writing your right to have a jury trial. In that case, you would have what's called a court or bench trial, meaning instead of a jury hearing the evidence, the judge would hear the evidence, the judge would apply the law, and the judge would decide whether or not the state proved your guilt. Do you understand that?
Yes, Your Honor.
Now, under the Constitution, you have a right to use to confront witnesses against you in open court and to have your attorney cross-examine them. What that means is witnesses against you have to come into court and testify in front of you and your attorney and anyone else is present. After the prosecutor's done asking questions, your attorney can ask questions. That's called cross-examination. The purpose of that would be to bring out evidence that helps your side of the case. Do you understand that?
Yes, Your Honor.
Now, under the Constitution, you have a right to use the power of the court to compel or force witnesses to come into court to testify for you, just like the state. So if you have witnesses you're not certain are going to come in voluntarily at your request, the court issues a court order. That's called a subpoena. And that forces those people to come to court to testify for you if you want them to, even though they don't want to be involved. And that's the same way state's witnesses are forced to come in to testify against you. Do you understand that?
Yes, Your Honor.
And under the Constitution, you have a privilege against self-incrimination, which means that you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can. It's your decision. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time in the proceedings. And in fact, no one can even comment about it except in one situation. If there's a jury trial and you don't testify, the judge instructs the jury that because that's your right, they cannot consider it for any purpose. Do you understand that?
Yes, Your Honor.
Under the Constitution, you have a presumption of innocence, which means that you're presumed innocent of both of these charges until the state proves you're guilty by proof beyond a reasonable doubt on all the essential elements of each offense. So, you are not required to try to prove that you're not guilty simply because you've been accused. In fact, under the law, you're not required to present any evidence in your own defense. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state to prove your guilt by proof beyond a reasonable doubt on every essential element of the offense charged, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, Your Honor.
All right, now, originally you pled not guilty. Not guilty plea denied the allegations in the indictment, denied you committed a crime, and it exercised or invoked all the rights I've just described. If you change your plea from not guilty to guilty, it's the opposite of the not guilty plea. Guilty plea, as to counts 1 and 4, would admit the allegations in each count, admit that they're a crime, that you committed that crime. And that plea would waive or give up all the rights I've expressed to, or explained to you today, except your right to have an attorney, which you always have. But other than that, your plea of guilty would waive or give up your right to a jury or court trial, waive or give up your right to confront witnesses against you and cross-examine through your attorney, waive or give up your right to use the power of the court to compel or force witnesses to come to court to testify for you, just like the state, and waive or give up your privilege against self-incrimination because you're saying you're guilty, that's what's used to find you guilty. And waive or gives up your presumption of innocence because if you say you're guilty, the state doesn't have to prove you're guilty. It also subjects you to being sentenced immediately by the court, although I'm not going to do that. And finally, it waives or gives up any right to file an appeal you think you may have had up until this point in the case. Now, if I should sentence you the maximum sentence, or under certain circumstances you can file an appeal, that would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
Yes, Your Honor.
And are you a U.S. citizen?
Yes, Your Honor.
Now, do you have any questions about the charge or the possible penalty?
Actually, I do have one question.
All right.
What if, let's say, it don't work out in this treatment programs, Can I move treatment programs as long as I stay in treatment?
Well, that depends on what the probation department says. So you have to comply with the treatment program right now, but, you know, if they recommend or think that it's in your best interest to go to a different facility, you know, that's okay. If you get kicked out because you didn't comply, then that's a violation. Now, if you got right back into treatment, I guess that would be something that you and the probation department have to talk about. It's up to them whether they file a violation. But, you know, you just can't drop out of one and go to other willy-nilly on your own. You know, once you do this, you're under supervision. You have to stay in that program until they approve you going to a different one.
All right, Your Honor.
All right, does that answer your question?
Yep.
All right, any other questions?
Nope. No, Your Honor.
Then is it your decision to plead guilty to counts 1 and 4 according to the plea agreement we've just gone over?
Yes, Your Honor.
All right, then as to charge in count 1, which alleges that on or about January 13, 2022 in Highland County, Ohio, you did, and along with Zindell Russell, knowingly by force, stealth, or deception, trespassing an unoccupied structure to wit 10709 North Shore Drive with purpose to commit therein a theft offense as defined in ORC 2913.02A1 or a felony in violation of 2911.13A. The charge of breaking and entering a 5th-degree felony, possible penalty of 6 to 12 months, fine of $2,500. How do you plead?
Guilty, Your Honor.
As to count 4, which alleges that on or about January 13, 2022 in Highland County, Ohio, you did knowingly obtain, possess, or use a Schedule II controlled substance to wit methamphetamine in violation of Section 2925.11 of the Higher Revised Code, charge of aggravated possession of methamphetamine, a 5th-degree felony, carrying possible penalty of 6 to 12 months in prison, a fine of $2,500, and a possible license suspension of 6 months to 5 years. How do you plead?
Guilty, Your Honor.
All right, the court finds that on this day in open court, the defendant was advised of all his constitutional rights, made a knowing, intelligent, voluntary waiver of the same pursuant to Criminal 11 to counts 1 and 4. The court finds that the defendant has filed a motion for intervention and that his drug usage was a factor that led to the criminal offense with which he's been charged, and intervention in lieu will not demean the seriousness of the offense and likely reduce the likelihood of any future criminal activity. He has been accepted in an appropriate certified treatment program and is participating in that. He's otherwise eligible for community control sanctions. He's not a repeat or dangerous offender, and he is otherwise eligible for intervention in lieu of conviction. Therefore, the court accepts the guilty plea, orders it filed. However, there will be no finding of guilt at this time. Rather, the proceedings will be stayed pending a report from the probation department as to the defendant's progress in the program. He is ordered to be on community control under the supervision of the probation department for a period of 2 years and the term set by the court. He's ordered to comply with all those conditions. He's required to successfully complete the intervention plan, including requirement to abstain from using drugs or alcohol for a period of 1 year. And should he successfully, he's also ordered to pay the court costs and any programming fees. And he is, if he successfully completes that plan and any other conditions of the community control is ordered, then the court will dismiss the case against him and there'll be no finding of guilt. If it's alleged that he has failed to complete or comply with the terms, conditions, then upon notice from the court, probation department in writing, the court will conduct a hearing at which the defendant will be represented by counsel to determine if he's failed to comply. And at that time, if that occurs, then he could be sentenced to, if he's found that he's failed to comply, he could have his participation in the program revoked. He will be found guilty and the court can imprison him for a period of 6 to 24 months and fine him $5,000. All right, is there anything further from counsel?
No, Your Honor.
No, Your Honor.
All right, this completes the case then, Mr. McComas. You'll need to stay in touch with Mr. Arjima there. You're not under the pretrial supervision conditions anymore. You'll be under the new conditions and they'll go over those with you and you'll be required to comply with those as well as your treatment plan. All right, thank you.
Yes, Your Honor. Thank you.
All right, are you Mr. Bennett there?
Your Honor.
All right, this is case number 23 CR 47, State of Ohio versus David Allen Bennett. This is a hearing being conducted by Zoom. Mr. Bennett's appearing from the Justice Center. His attorney is Sarah Barger, appearing from her office, appearing from the prosecutor's office, assistant prosecutor, or is prosecuting attorney Collins. The defendant is charged with aggravated possession of methamphetamine, 3rd-degree felony. The matter is set for trial, I believe, later this month. The court has received a plea of guilty form, which indicates that he's going to withdraw his not guilty plea and plead guilty. Now, Ms. Barger, you and your client both are in agreement that this hearing can be conducted by Zoom rather than personal appearance in the courtroom.
Yes, Your Honor.
And you're all right with that, Mr. Bennett?
Yes, sir, Your Honor.
All right. Now, since you're not in the courtroom, seated next to her, if at any time you have a question, you just tell me and I'll put you and her into what's called a breakout room. It'll be just the two of you on the screen. The deputy will step out of the room and you'll be able to talk with her with confidence without anybody seeing or hearing you. Okay?
Okay, Your Honor.
Now, defendant's charged, as I said, with aggravated possession of methamphetamine, and his plea of guilty form I've been presented says you're going to plead guilty to that charge under 2925.11 of the Ohio Revised Code, a third-degree felony. And I'm going to hold this up to the screen to make sure you recognize this form. See that form there, Mr. Bennett?
Yes, Your Honor.
You recognize it?
Yes, Your Honor.
It's page 1. All right, now on page 3, about a fourth of the way down, there's a sentence that says, I enter this plea voluntarily. Next to that, there's a signature defendant line, and it looks like David A. Bennett, 33123. And I'll hold that up to the screen and ask if that is your signature and right in
Yes,
there.
Your Honor.
And is that the date you signed this agreement?
Yes, Your Honor.
And when you signed it, did you understand it was an agreement to plead guilty, which means there's not going to be a trial? The next step would be a sentencing hearing?
Yes, Your Honor.
And did you talk to your attorney about this and have her explain everything to you before you signed it?
Yes, Your Honor.
And did you feel you had enough time to fully consider this matter before making this decision?
Yes, Your Honor.
And it's been about 5 days since you signed it. Is this still what you want to do?
Yes, Your Honor.
All right, now, the agreement says you're going to plead guilty to that charge, and it says on page 1, you understand the maximum prison term for that could be 36 months in prison. The minimum is 9. There's certain increments in between. There's a fine of $10,000 available and a possible license suspension of 6 months to 5 years. Prison term is presumed, but not mandatory. Do you understand that?
Yes, Your Honor.
Are you facing any felony charges anywhere else?
No, sir.
Are you currently on probation, parole, community control, or post-release control for a felony from any other jurisdiction?
No, Your Honor.
Right now, under the law, if you're convicted of this and sentenced to prison, Mr. Bennett, upon completion of that prison term, it's possible the Adult Parole Authority may choose to put you under post-release control for a period of up to 2 years, which means you'd be supervised under the terms they set by a parole officer. And if during that period of time they determine that you have not complied, they could return you to prison to make you serve an additional period of up to 9 months for any single violation, but there is a cap or limit of half of your prison term for all violations. But if you commit a new felony, then in addition to whatever sentence the judge in that new case can impose upon you, the judge could also sentence you for committing that offense while under post-release control in this case to an additional period of a year, whatever time is left on that period of post-release control, whichever is greater. If that occurred, that would be served consecutively the sentence in the new case. You understand that?
Yes, Your Honor.
Now, as I said, it's presumed that this offense should result in prison term, but it's not mandatory. So legally, it's possible that you could be put under community control as an option, and that means you'd be supervised for up to 5 years by a probation officer under terms set by the court. And if during that period of time probation felt that you were non-compliant, they would file written notice of that with the court. You would be given a copy. There would be a hearing. The outcome of that hearing was that you failed to comply, and then at that time the court could revoke your community control and then sentence you to prison for 36 months and fine you $10,000. You understand that?
Yes, Your Honor.
All right, now, the charge alleges that on or about November 4 of 2022 in this county, you did knowingly obtain, possess, or use a Schedule II controlled substance, to wit methamphetamine, an amount equal to or exceeding bulk amount but less than 5 times bulk amount, violation of Section 2925.11. So that's the third-degree felony with a possible prison term between 9 and 36 months, in the increments provided by law, a fine of $10,000, and a possible license suspension of 6 months to 5 years. Now, do you understand what it is you've been charged with, what the state said you did, when, where, and how they alleged you did it?
Yes, Your Honor.
Have you discussed the nature of that charge, the evidence in the case, possible legal issues in the case, the possible defenses you could try to raise at trial, and the possible outcomes of a trial with your attorney?
Yes, Your Honor.
Are you satisfied with their advice and competence in this matter?
Yes, Your Honor.
Are you under the influence of any types of drugs or alcohol at this time?
No, Your Honor.
Has any threat been made to make you plead guilty here today?
No, Your Honor.
Now, on page 2, there's a couple of lines that have been printed in bold and underlined, and then the third sentence is stricken out and indicated it doesn't apply. So I'll read what applies as follows. Defendant shall enter a plea of guilty to the indictment. State and defense jointly recommend 18 months incarceration. Is that your understanding of the agreement?
Yes, Your
Does
Honor.
anyone promise you anything other than that to get you to plead guilty here today?
No, Your Honor.
Right, now, do you hold any license or certification from any state governmental agency that regulates or supervises any occupation or profession in this state?
No, Your Honor.
Now, you have certain constitutional rights you must understand before I can accept a plea from you. First, you have a right to have an attorney. You were given, I appointed Ms. Barger to represent you since you were unable to pay for your own attorney. Now, her appointment wasn't simply to work the case out, but to provide any defense that could be available to you under the law that you would like her to provide. So if you decide that you do not want to plead guilty, that you want to defend against this charge, she will continue to represent you and defend you, including a trial, if that's what you want. Do you understand that?
Yes, Your Honor.
Right, now, under the Constitution, you have a right to have a jury trial in this matter, in which 12 people would be selected from a group of citizens that are summoned for jury duty on your trial date. After they are selected, the evidence will be presented, and then they'd be instructed on the law by the judge, and that jury then would decide by unanimous verdict, meaning all 12 of them would have to agree on whether the state proved your guilt. Now, if you did not want to have a jury trial, but you did not want to plead guilty, you can waive in writing, which means to give up, your right to have a jury trial, and in that case, you would have what's called a court or bench trial, meaning instead of a jury hearing the evidence, the judge would be the one who would hear the evidence, apply the law, and decide whether or not the state proves your guilt. Do you understand that?
Yes, Your Honor.
Right, now, under the Constitution, you have a right to confront the witness against you in open court and to cross-examine them through your attorney. What that means is that the witnesses against you have to come into court and testify in front of you and your attorney and anyone else who may be present. After the prosecutor's done asking those witnesses questions, your attorney asks questions. That's called cross-examination. The purpose of that would be to try to bring out evidence that helps your side of the case. Do you understand that?
Yes, Your Honor.
Right, now, under the Constitution, you have a right to use the power of the court to compel or force witnesses to come to court to testify on your behalf, just like the state. So if you have witnesses you're not certain are going to come in voluntarily, at your request, the court issues a court order called a subpoena, and that forces those witnesses to come to court to be available to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are forced to come to court to testify against you. Do you understand that?
Yes, Your Honor.
All right, now under the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including the trial. No one can ever make you testify. The prosecutor can't, the judge can, it's up to you. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time in the proceedings. And in fact, no one's even allowed to comment about it except in one situation. If there's a jury trial and you do not testify, the judge instructs the jury that because that's your right, they cannot consider it for any purpose. Do you understand that?
Yes, Your Honor.
Right now, under the Constitution, you're presumed innocent of this charge shall proven guilty by the state of Ohio in every essential element of the offense charged. What that means is that the burden of proof isn't on you to try to prove you're not guilty simply because you've been accused. In fact, under the law, you're not required to present any evidence in your own defense in trial. You may, but you're not required to. But whether you present evidence on your own behalf or not, the state of Ohio will retain the burden of proving your guilt by proof beyond a reasonable doubt on every essential element of the offense charged, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, Your Honor.
Right now, originally you entered a plea of not guilty, Mr. Bennett. That plea denied the allegation in the indictment, denied you committed any crime, and it exercised or invoked all the rights that I've just described for you. Now, if you change your plea from not guilty to guilty, that is the complete opposite of the not guilty plea. The guilty plea will admit the allegations in the indictment, admit that they're a crime, that you committed that crime. Now, that plea waives and gives up all the rights that I've described for you today, except the right to have counsel, which you always have no matter what your plea. But with that exception, the plea of guilty will admit or will waive or give up your right to a jury or court trial, will waive or give up your right to confront witnesses and cross-examine them through your attorney in open court, will waive or give up your right to use the power of this court to compel witnesses to appear before the court to testify on your behalf, the same as the state. It will waive or give up your privilege against self-incrimination, because if you say you're guilty, that is what's used to find you guilty. It'll waive or give up your presumption of innocence, because if you say you're guilty, the state doesn't have to prove you're guilty. It waives or gives up your right to file an appeal on any alleged violations of your rights you feel may have occurred up to this point in the case. And finally, it subjects you to being sentenced immediately by the court, which I believe is what's being recommended in this plea agreement. Do you understand all of that?
Yes, Your Honor.
And are you a U.S. citizen, Mr. Bennett?
Yes, Your Honor.
Right. Do you have any questions about the charge or the possible penalties?
No, Your Honor.
You understand it?
Yes, Your Honor.
Have any questions about the plea agreement?
No, Your Honor.
You understand that?
Yes, Your Honor.
And I don't think I said it earlier, but I am not required to follow the sentencing recommendation. So if you plead guilty, I could determine that you should be sentenced to a longer or shorter period of time as I determine is appropriate. You understand that?
Yes, Your Honor.
You have any questions about the constitutional rights I've explained?
No, Your Honor.
You understand those?
Yes, Your Honor.
You have any questions about the plea of guilty, what it means, what will happen if you enter that plea here today?
No, Your Honor.
You understand that?
Yes, Your Honor.
Now, is there anything you'd like to speak with your attorney about before we go any further?
No, Your Honor.
You have any questions about anything I've explained here today?
No, Your Honor.
Then is it your decision to withdraw your not guilty plea, plead guilty to the charge according to the terms of this plea agreement that we've just gone over?
Yes, Your Honor.
All right, then as to the charge which alleges that on or about November 4, 2022 in Highland County, Ohio, you did knowingly obtain, possess, or use a Schedule II controlled substance, to wit methamphetamine, an amount equal to or exceeding bulk amount but less than 5 times bulk amount in violation of Section 2925.11 of the Ohio Revised Code, in charge of aggravated possession of methamphetamine, a third-degree felony, carrying possible prison term between 9 and 36 months in increments provided by law, a fine of up to $10,000, and a possible license suspension of 6 months to 5 years. How do you plead?
Guilty, Your Honor.
All right, the court finds on this day in open court, defendants advised of all his constitutional rights, made a knowing, intelligent, voluntary waiver of those pursuant to Criminal Rule 11. Please accept and order filed. The defendant is found guilty of the charge as set forth in the indictment, a third-degree felony. Now, based on the fact that the parties have reached a stipulated recommendation as to sentencing, there's no request for a pre-sentence report, and I believe that the discovery lists Mr. Bennett's previous record, so therefore the court's not going to order a pre-sentence report. I'll proceed with sentencing forthwith. All right, Ms. Collins, on behalf of the state.
Your Honor, this state would request the court follow the joint recommendation as outlined in the plea agreement, noting the defendant's prior criminal history, as well as the fact that there is a presumption for prison in this case based on the quantity of methamphetamine the defendant had in his possession. So based on all that, we would ask the court to follow the joint recommendation. Thank you.
All right. Oh, there she is, Ms. Berger. I lost you on my screen. It keeps moving people around as more people come in. Anything on behalf of the defendant?
Your Honor, we would just request that you follow the recommendation at this time. My client is accepting his responsibility in this and is ready to move forward.
All right, Mr. Bennett, anything that you would like to say? You're not required to say anything, but I'll hear whatever you have to say.
No, Your Honor.
Let's see. I see you're what? Are you 50 yet, or you're going to turn 50 this year?
I'm 50 now. I'll be 51 this year.
51 this year. Okay. Well, that's right. It's, years get away from me. Mr. Bennett, you've been a regular visitor through this court for 21 years. First felony was in 2002 when you got intervention, and then ended up having that revoked, going to prison. It seems like just about every 2 or 3 years you keep coming back. It's kind of like this is your favorite vacation spot or something, but you need to quit. And I hope that you're getting the point that you understand that before you kill yourself. That's going to be your decision. No one can do it for you. But you have a lot of this. This was a significant amount. You've been trafficking in the past, but sooner or later it's going to catch up to you. So I hope that you'll think about that, and that this will be the last time I see you, alive or dead. So it's the order of the court that you be sentenced to the Correctional Reception Center in Orion, Ohio, for a period of 18 months. According to this report from the sheriff, you were arrested on February the 8th. Is that correct?
Yes.
All right, so that's 51 days of jail time credit. Now, upon completion of the prison term, Mr. Bennett, it is possible the Adult Parole Authority will put you under post-release control for a period of up to 2 years. They don't have to, but it's optional, but they'll make that decision. If they do, you'll be supervised by a parole officer, and if you violate any of the conditions they've set forth, they can return you to prison even though you serve the entire term set by the court for an additional period of up to 9 months for one or more violations. However, should you be convicted of a felony while under post-release control, then in addition, whatever sentence a judge in the new case can impose upon you, that judge could also sentence you for committing that offense while under post-release control in this case to an additional period of a year or whatever time is left on that period of post-release control, whichever is greater. And if that occurs, that must be served consecutively to the sentence in the new case. You're also ordered to pay the court costs. for which judgment is granted and execution is ordered. If you fail to do that, then the court could permit you to do community service once you've completed your prison term in this county, and you'd be given credit for each hour you work in an hourly rate set by the court. Each hour you work will reduce your judgment by that amount until paid in full. All right, is there anything further from counsel?
No, Your Honor.
No, Your Honor.
You're remanded to custody then, Mr. Bennett. Thank you.
Thank you. Thank you, Your Honor.
His attorney is William Armentrout, appearing from his office. Appearing from the prosecutor's office, the prosecuting attorney Collins. The defendant is charged with receiving stolen property, theft, and identity fraud. This is a final pretrial, and I believe we have a trial date coming up in later this month. I believe that the 24th of April.
It is.
All right, April 24th is the trial date. Now, where do we stand on this, counsel?
Your Honor, my client has accepted the offer of the state. I just have to have him, and he's aware, he has to come and sign the plea form, so we'd ask to, schedule it for a plea hearing one day next week if we could.
Let's see, are you coming over Monday, the 10th?
Well, I think you told me you were going to set.
Oh, yeah, you are. You're going to be here for Mr. Brown at a.
Was that at 8:30?
Yeah, it said on the notice 8. We'll expect him to be here at 8, but the attorney's going to be here at 8:30 because I vacated the jury trial since it was not supposed to go forward. So we'll do it at 8:30, and then Mr. Harner, you be here at 9 a.m. on Monday, April the 10th. All right. Any questions, Mr. Harner?
No, sir.
All right. Thank you.
All right. Thank you.
All right. Now, sir, the uh, 23 CR 37, State of Ohio versus Richard Wilson. Mr. Wilson is appearing on the screen. It's marked SCHOK Volt SV 55. This is a Zoom hearing, final or a pretrial. His attorney is William Armentrout.
Sarah Barger.
Oh no, I'm sorry, Sarah Barger. Yeah. All right, Sarah Barger. She's appearing from her office. Appearing on behalf of the state is Prosecuting Attorney Collins. Defendants charged with aggravated trafficking in methamphetamine and aggravated possession of methamphetamine, 4th and 5th degree felonies. This is the first pretrial. Final pretrial set on the 19th, and we have a trial date on May 11. I see the state's provided discovery, and well, let's see. Yeah, here it is. Bill particulars discovery. All right. You received that, Ms. Barger?
Yes, Your Honor.
Okay. Your discovery is due by the final pretrial. And do you anticipate any pretrial motions?
Not at this time.
She's filed her discovery, Judge.
Pardon me?
She's filed her discovery.
Yes, she did. Yeah, you've responded, I believe.
Yes.
Yeah, right. Her discovery will be due by the final pretrial.
No, that's what I'm saying. She's already filed hers.
Oh, okay. Well, I don't see that. So it's probably
Okay.
just not caught up to the file yet from the clerk's office. Okay. And you don't anticipate any written or any pretrial motions?
Not at this time.
All right. And has there been a written plea offer provided?
There has been, Your Honor.
Is your client aware of that, Ms. Barger?
Not yet. He needs to get a hold of me.
Okay. All right, so Mr. Wilson, you heard that. You've got her phone number? All right.
Yes,
When we
sir.
get done here, call her in a little while and try to get an appointment set up so you can discuss your case with her. And
Okay, I'll make sure I get a hold of her. I'll make sure I get a hold of her today.
All right, good. And we'll have our next pretrial, which will be by Zoom on April 19th. All right, thank you.
Okay.
Well, let's see. His attorney is Miss Witt. She's not here yet. All right. So take him off. This is a Zoom hearing, pre-trial. Ms. Dixon is represented by Catherine Hapner, appearing from her office. Appearing on behalf of the state is Prosecuting Attorney Collins. This was a matter set for a final pre-trial. Ms. Dixon is charged with a fifth-degree felony. I actually do have a proposed plea agreement, but then I also see a note on the docket, Ms. Hapner, that your client is in Kenton County Jail.
She is, Your Honor. She's in the Kenton County, Kentucky jail. She has a hearing at 1:30 this morning. I'm sorry, this afternoon. I don't know whether that hearing has occurred yet or not.
Okay. Do you know what she's down there for? Is it a misdemeanor or what?
Misdemeanors. Yeah. There's a drug paraphernalia and a misdemeanor possession.
All right. Well, what we'll do is we'll continue this matter. Due to the unavailability of the defendant, the speedy trial time will be told. And let's see, was this a final pretrial?
It is. It looks like trial is the 27th.
All right. Well, what I'll do then is I'm going to vacate the trial date. We'll put the case on the inactive docket pending a report about her whereabouts, and I'll set this for another plea hearing. Let's see here. Do it in about 2 weeks. Do you know what kind of misdemeanor it is, Miss Hapner?
There's a drug paraphernalia,
Okay.
and then the other just says misdemeanor first offense possession.
Okay.
So it doesn't give me a whole lot of information.
Right, all right. Well, let's set this for a pretrial on May the 3rd, or a plea hearing on May the 3rd at, let's see, that's a Wednesday. What about 11 a.m. on that day? Would you be available then?
Yep, that works for me.
All right. We'll set it at 11 a.m. at that time. And then we'll try, if you would, see if you can monitor. And Mr. Arjima, if you kind of watch take a look at Kenton County as well. And because if she does get out, then she should report to you pretty quickly. So.
Yeah, it was news to us.
Okay. All right. Thank you.
And then, Your Honor, I also have, you said, I know you mentioned that Ms. Dixon was the only one I have. I have Jeremy Hogsett also. I inherited him from Mr. Armentrout last week.
Yeah, Mr. Hogsett. Yeah. He's not on.
He's here if you'd like me to get him.
All right. Go ahead and get him then. All right, please. Huh?
I like how you said you inherited it from Mr. Armentrout.
Yeah, he is.
Bill was probably happy to bequeath that to me.
I
State of Ohio versus Jeremy E. Hogsett. And you're Jeremy E. Hogsett, appearing from the probation department?
Yes, Your Honor.
All right, this is a pretrial being conducted by Zoom. Mr. Hogsett's attorney is Catherine Hapner, appearing from her office, and appearing from the prosecutor's office is Prosecuting Attorney Collins. The defendant is charged with a grand theft, a 4-3 felony, and a tampering with records, a first-degree misdemeanor. I had appointed originally Mr. Armentrout, and then he had to withdraw due to a conflict, and Ms. Hapner was appointed back on the 14th of March. Have you gotten the file from Mr. Armentrout, the discovery and the bill?
I got it yesterday, Your Honor.
Okay, all right. And I believe this matter might be set for trial fairly soon.
I think that's correct.
Let me look here.
The 27th.
27th, all right.
Yeah, and Your Honor, I've got a whole docket of other cases that day. So I would have to, and because I just got the discovery yesterday, I would request a continuance of that trial date.
All right. Have you got all of the discovery in terms of records and all that stuff that I assume is involved in this case?
As far as I know, I've got everything.
All right. Was that on a thumb drive or something?
No, it was in my tray at the clerk's office.
Oh, okay. All
So
right.
if there's anything electronic, I don't have that.
Was there anything electronic, Ms. Collins?
No, Your Honor.
Okay.
Oh, I'm sorry. Yes, Your Honor. There are videos of interviews and photographs that we would make available upon a USB being provided by defense counsel. I don't believe Mr. Armentrout gave us the USB, but Ms. Hapner, if you want to drop one off, we will.
Certainly. Yep, I'll do that.
All right. Well, I'm going to go ahead and grant the continuance since Ms. Hapner just got into the case about 3 weeks ago or so. So I'm going to continue the matter. We'll set this for another pre-trial on May the 3rd at 2:15. The matter will be set for jury trial then on okay, let's see, this case started out January 25th. So we'll set it for June. I want to get a firm trial date here because there won't be any more continuances. So is June 12th available on your calendar, Ms. Hapner?
No, Your Honor, that's my regular morning in Fayette County.
All right, what about the 15th?
That works for me.
All right, June the 15th at 8 a.m. And there won't be any further continuances. That's more than 2 months, and that should be enough time to get the matter ready for trial. Final pretrial May the 3rd. That'll also be your deadline to file any pretrial motions and provide your discovery to the state. And do you anticipate any other discovery coming from the state, Mrs. Collins? Any further documents or anything?
There are bank records that are on that we have digitally that we'll provide with the USB, and then some interviews and things. But,
okay, but I'm saying you have everything that you know of will be on the USB.
Yes.
In addition to whatever's already been provided in paper form.
Yes, that's all that we have.
Okay, all right. Now, any other matters to discuss at this time?
Nothing I'm aware of.
All right, so Mr. Hogsett, you won't have to be here on the 27th. You'll be here May the 3rd at 2:15. And we'll do that in person here at the courthouse. Jury trial will be set for June the 15th at 8 a.m. Of course, that's in person as well. All right, thank you.
And Your Honor, while I'm still on here, Ms. Witt sent me a text that said she had not even gone into her hearing yet in Adams County as of 1:30 and asked me to cover for her.
All right, and her case is what?
Tyler Hunley.
All right.
It's a plea hearing, Your Honor.
Okay, well, we can't do a plea hearing with the substitute counsel, so send her a text
Okay.
back and tell her to, let us know when she gets out of that, and we have some other matters. So, Mr. Hunley, you'll just have to hang on for right now until your attorney gets out of the Adams County Court. All right.
Great. Thank you, Your Honor.
Thank you. All right, if you would unmute yourself there, Mr. Florence.
Okay.
Thank you. All right, this is case number 23 CR 17, State of Ohio versus Jaden Florence. And you're Jaden Florence appearing there from the probation department?
Yes.
All right, this is a hearing, pretrial hearing being conducted by Zoom. Mr. Florence is appearing from the probation department. His attorney is William Armentrout. Appearing from his office, appearing from the prosecutor's office is prosecuting attorney Collins. Defendant is charged along with the co-defendant Tristan Nelson with theft, breaking, entering, and receiving stolen property. This is a first pretrial, and I believe we have a trial date of June the 12th. The final pretrial is May 3rd. I see that the state has provided bill particulars and discovery. Mr. Armentrout provided his discovery. Does that complete discovery as far as everyone knows?
Yes, Your Honor.
I believe so, Your Honor.
All right, and Mr. Armentrout, do you anticipate any pretrial motions?
No.
Has there been a written plea offer provided?
Yes, Your Honor.
My client's not familiar with it, and I have his discovery here. And Mr. Florence, you'll need to contact my office tomorrow, get an appointment to come in to go over these documents, okay?
Yes, sir.
All right, are there any other matters to discuss then?
No, Your Honor.
All right, then Mr. Florence, make sure you get in touch with Mr. Armentrout as he requested, so you can discuss your case and be back here for your next pretrial. All right, thank you.
Yes, Your Honor.
All right, let's see, Lit has Alvera. All right, this is case number 23CR29, State of Ohio versus Jennifer M. Baker. Appearing on behalf of the state, Prosecutor Attorney Collins and Assistant Prosecutor King. Appearing on behalf of defendants, James Bolger. You are Jennifer M. Baker?
Yes.
All right, Ms. Baker is charged with felonious assault, aggravated assault, and a forfeiture specification. This is a final pre-trial. Trial is set for the 27th of April. Now, I see that discovery was previously provided on February the 21st from the state. Mr. Bolger, do you have any discovery?
Neither one. You make a copy.
Yes, Your Honor, we filed it, I think it was e-filed this morning.
This morning? Okay. Have you gotten it yet?
Yes, they were able to email it to me this afternoon.
Okay. All right. And there are no pretrial motions, or have there been any pretrial motions filed by the defense?
No, not for the defendant.
All right.
The state did, though.
Yes, I have yours. All right. All right, I have them. This was filed 2 days ago. Motion in limine. You received this, Mr. Bolger?
I did.
All right, Ms. Collins, wish to address this?
Your Honor, essentially, I'm kind of reading between the lines here based not only on a public records request that Mr. Bolger sent to the Sheriff's Office last week, but also based on his compliance with discovery I received this afternoon. He is referencing several things that date back to August and October of 2022, which I believe to be situations between a Terry Shanks and the defendant, or a Terry Shanks and the defendant's daughter. The state's position is that all of this is wholly irrelevant. The reason that it's wholly irrelevant is, well, first of all, it's completely away in time from the event that she's indicted for. Secondly, Terry Shanks is not the person that she shot at. So it's the state's position, and my understanding from what Mr. Bolger has provided, that he's trying to build a self-defense claim, basically, that she was in such fear that she used a deadly weapon in order to defend herself from somebody that was driving down a public road, and she was in fear of Terry Shanks. The problem with this entire defense is that she shot at Wade Page. It wasn't Terry Shanks.
Shanks is the name?
Terry Shanks is the person's name that she's talking about. That's not who was driving the vehicle. And it wasn't his vehicle. It was Wade Page.
Is that any of that information listed on his discovery?
The defendant's discovery?
That you just got? Okay.
Absolutely.
All right. Mr. Bolger?
Yes. Your Honor, I believe that if there was an attempt to put on evidence that would support a self-defense instruction, the context in which the conduct occurs is extremely important, and it's for the jury to consider the history that led up to the incident. Now, there's no question here that there's a mistake on the part of my client, but the standard jury instructions refer to an honest belief, which the Ohio Supreme Court has also interpreted as including the issue of mistake. And she made a mistake, but she made
mistake as to identity, or mistake as to being allowed to use? Most of the cases I'm familiar with, mistake refers to the fact that it wasn't appropriate, but it was an honest mistake. I'm not aware of any cases about shooting another person where they thought they were a different person. Well, is there case law on that?
I don't have any to present you with now. I realize you're considering an eliminate ruling, which would only be ripe into a final decision.
Right, I agree. Well, what I'm going to do is this. I'm going to ask each of you to brief the issue. I'm going to withhold ruling. Of course, any motion in limine is just a preliminary ruling anyway. It will have to be decided at trial based upon what the evidence is in trial. And I'll have to take a look at that, but I'd be interested in seeing, because I think that mistake is always been, as I've understood it, and again, things have changed with all the statutory amendments, and I'll have to look at those, but I've always been in a belief that mistake was as to the circumstances, whether there was actual fear or whether of deadly harm and whether they were permitted to use it. It's subjective, not objective. And so, you know, I'll look at any case law that either side can present regarding that issue, and we can discuss it, you know, the morning of trial, unless there's some other pre-trials before then. Now, Ms. Collins, you've stood, so I assume that means you would like to speak.
Also, as I would bring up also, and I think I even talked about this in my brief, was the other issue is that self-defense, and I agree that there are so many allowances now to self-defense, but a person driving by on a public roadway and a person shooting from a private residence does not self-defense make.
I think that would probably be true. My question, though, is that a question of fact for the jury, or is that a question of law? And I'm going to have to look at the case, the statute, because there have been so many changes in the last year or so between that and carry, conceal, or gun rights that it's hard to keep up. They seem to pass another law every month. And so I'll have to look at it. You know, again, in the past at least, the court did have the authority to determine whether the evidence was sufficient to warrant an instruction on self-defense. I think that is still the law, but again, I want to look at that too. And so I will say that, you know, if this was a situation as you described, if that is the evidence that this car drove down the road, she was wherever she was and she shot at it, unless she was standing in the road alongside the road and thought the car was going to run into her, in which case it wouldn't matter who the identity was, then you know, there may or may not be enough evidence to warrant a self-defense instruction. So I guess that's something that if you would like to, and actually I don't know if you would like to get this done a little quicker and get a preliminary idea from me, if that has any bearing on, because I assume that would have a bearing on the trial strategy and so forth. So how about today is the 5th, the trial is set the 27th. So how about a week from today for memos? Is that doable for you, Mr. Bolger? Can you do that in a week, Mr. Bolger?
Yes, Your Honor, I think I can.
All right, so I'll order briefs due April 12 by 4 p.m. And then I'll try to get you a ruling by Friday following, so that'll give you an idea what I think is going to happen. Now, again, keep in mind, well, you're both experienced, you both know this. The motion to eliminate is just preliminary and is subject to change at any time based upon the state of the evidence at the trial. So, but at least it will give everyone an idea where I'm thinking the law is that will govern the trial and give you your ability to plan accordingly. Let's see, now the 27th is a Thursday. Now, how many witnesses are you anticipating on your side?
Not many, I think 5 at most.
Okay, on your side?
Your Honor, probably no more than that for the defense as well, and it may be less than that.
How many?
It could be as many as 5. We have 2 unidentified deputies that I've referenced in the discovery. I'm hoping that the public records request will provide their identities to me, so I may have to supplement discovery in this case once I get the public records.
Doesn't sound like those would be terribly long. So I think 2 days is probably sufficient to try this. Both of you agree?
I do.
I do.
Okay, good. All right. Because we only have 2 days set, and that's a Thursday, and I don't want to go. I mean, we can go late if we have to on both days, but because otherwise, and I'm not sure, the 26th, for some reason, there seems to me there's something important that I'm supposed to do that day. I can't remember what it is. I was thinking we could maybe move it up a day. But have you already subpoenaed witnesses?
I have not.
No.
I have misidentified Wade Pages. He's the alleged victim in this case.
He's in prison.
He is in prison.
You're requesting him to be brought back? Well, you're going to bring him back.
We're bringing him back.
Okay.
Absolutely.
I have misidentified who I believe to be his wife and present at the home where he was arrested. I think I've identified his ex-wife.
Okay.
I have the name of a person I think may be the female who identified herself as the wife that night, but I haven't provided the state yet. I haven't verified.
Well, you're going to give that to him, so you're looking for the wife. Okay.
Right.
Give me the calendar. We'll just take a look here. Would you be available on the 26th if we can do the 26th? The day before?
April
Yeah.
26th.
That's a Wednesday.
What time of the day would that be, Your Honor?
Let's start in the morning. I'm just looking here to see if we need it. I don't know if I have it available. I'm looking here. I'm just talking out loud, thinking out loud here.
I think I probably would be.
Okay.
We do it earlier in the morning. Great.
Yeah, it would be like at 8 o'clock or 8:30. Normally we start 8:15 or 8 o'clock for council and 8:15 for jurors. Oh, I have a doctor's appointment at 8 o'clock. Okay. Also supposed to do arraignments at 8:30. Well, we could. Those are people that aren't in custody. We could actually move those to the 20. Well, that was for the jury that we just had, though, wasn't it? Yeah, that's already set. Yeah, that's going to be. Those are summons that will be issued for that date, so they're already set to come in at 8:30.
2 days will be enough time to
You think
try
2 days?
this.
All right, let's just stick with it. All right, let's just go with that then. All right. All right, anything else?
No, Your Honor.
All right, thank you. All righty. State of Ohio versus Daniel Miller. Mr. Miller, this is a Zoom hearing, pre-trial. Mr. Miller is appearing on the screen, marked Daniel Miller, and William Satina is appearing on behalf of the defendant from his office on the page marked William A's iPhone, and present for the state's prosecuting attorney Collins. The defendant is charged with felonious assault, a second-degree felony. I believe this is a first pre-trial, and we have a trial date of June 12th with a final pre-trial on the 3rd of May. See, the state provided discovery to the defense, and you received that, Mr. Satina?
I did, Your Honor.
All right. I don't see any discovery yet from you, but yours is due by the final pre-trial. Do you anticipate any pre-trial motions?
From the defense?
Yes.
Not as of today, Your Honor, no.
Okay. Well, if you do determine there are any to be filed, those will be due by the final pre-trial as well.
I did file a notice of defense of others pursuant to Criminal Rule 12.2. Those are in the mail. I've faxed those to the clerk, and I've emailed and faxed those to prosecution.
Okay. All right. Has there been a written plea offer provided?
There has been, Your Honor.
All right. You received that, Mr. Satina?
I have, Your Honor.
Is your client aware of that?
He is.
All right. Okay. Any other matters that we need to discuss at this point?
No, Your Honor.
All right. Lynn,
No,
as
Your
indicated, we'll need any additional discovery by either side by the final pretrial and any additional motions by the final pretrial. All right, we'll see you back here with that. The next final pretrial will be by Zoom as well, Mr. Miller and Mr. Tina. So we'll send you a link. Thank you.
Thank you, sir.
Thank you, Your Honor.
All right. Fifth-degree felony. This is a first pretrial. The final pretrial is set for May 3 and trial set for June 12. I see that both sides have complied with discovery. Is that complete discovery as far as both of you are aware?
Yes, Your Honor.
Yes, Your Honor.
Do you anticipate any pretrial motions, Mr. Armentrout?
No, Your Honor.
All right. And has there been a written plea offer received?
There has. My client's aware of it. He's inclined to accept it. I just need to get, Brandon, I need you to get in here, call tomorrow, get an appointment to get in here next week to go through your paperwork.
I'm supposed to be there next Tuesday at 1 o'clock.
Oh, great.
All right.
We'll see you then.
Sounds good. All right. Thank you.
Thank you, Your Honor.
Thank you.
All right. Deputy there in Fayette County on the iPad. We have. And then, would you notify the jail that we need Mr. Hawkins back then too? We're ready to go.
Hunley, Judge.
Or Hunley, I mean, yeah, Hunley. All right, you're Robert Hawkins appearing there from Fayette County on the screen marked iPad?
Yes, sir.
All right, in this case number 22 CR 195, State of Ohio versus Robert O. Hawkins III. This is a pretrial being conducted by Zoom. Mr. Hawkins' attorney is Danielle Witt. She's appearing on her phone. Looks like from the Adams County Library. Is that right? Law Library?
That's right.
Yeah, I recognize it. All right. The prosecuting attorney is Annika Collins is appearing on behalf of the state. The defendant is charged with aggravated possession of methamphetamine, a fifth-degree felony. This is the first pretrial, final pretrial set on the 19th of April. Trial date is May 8th. I see that the state provided the bill of particulars and discovery. And you did receive that, Ms. Witt?
Yes, Your Honor.
All right. Well, your discovery will be due by the final pretrial. I don't see it yet. And do you anticipate any pretrial motions?
No, none at this time.
Has there been a written plea offer provided?
There has been, Your Honor.
Is your client aware of it yet?
Not yet. I will get out to the Fayette County Jail to meet with him.
All right. All right. Are there any other matters we need to discuss at this point?
No, Your Honor. No, Your Honor.
Mr. Hawkins, you have a court date for your case in Fayette County yet?
No, I'm already sentenced here.
Okay. What are you serving?
I get out, my release date's June 3rd.
June the 3rd. Okay. All right. Well, we'll talk about that then at the next pretrial. All right. We'll set up another pretrial, probably by Zoom as well. Ms. Witt does work up in Fayette County, so she indicates she's going to stop in to see you. She'll be talking with you. So, all right. Thank you, Deputy, for doing this. Appreciate it.
Your Honor.
Yeah.
I was OR'd on my last hearing.
Yeah.
Fayette County never got a fax saying I was OR'd. I was wondering if you could have something faxed up here for that, so I can work program.
Yeah, we'll check on that. We'll make sure that gets done. I'll make a note of it. All right.
All right. Thank you, Your Honor.
Mm-hmm. Case number 23 CR 31, State of Ohio versus Alicia Looney. Ms. Looney is appearing from the probation department. This is a pretrial by Zoom. Her attorney is Dennis Kirk, and he is appearing from his office, appearing from the prosecutor's office, Prosecuting Attorney Collins. The defendant is charged with theft along with Brandon Cannon. I see that discovery has been filed by both parties. Is that complete discovery, as far as you know?
Yes, Your Honor.
Yes, Your Honor.
You anticipate any pretrial motions, Mr. Kirk?
No, I do not.
And is there a written plea offer yet?
Yes,
There
Your Honor.
was, and I did relay that to my client, and I believe we'll have a resolution.
All right. Are there any other matters we need to discuss then at this time?
Not from the state.
No, Your Honor.
All right. So I think your next court date, Ms. Looney, is set for May the 3rd. That'll be by Zoom as well. But if there's anything done beforehand, then we'll schedule that. All right. Thank you.
Thank you.
All right. Mr. Hunley, if you would unmute yourself there or have the Tyler J. Hunley. Mr. Hunley is appearing from the jail. This is a final pretrial. It's being conducted by Zoom. Mr. Hunley's attorney is Danielle Witt, appearing on her phone by Zoom. And representing the state is the prosecuting attorney, Annika Collins, from her office. This is a plea hearing. Mr. Hunley is charged with 2 counts of misuse of a credit card and receiving stolen property. Now, Ms. Witt, do you and your client both agree to this plea hearing being conducted by Zoom rather than in-person appearance?
We do, Your Honor.
And your agreement with that, Mr. Hunley?
Yes, sir.
All right, Mr. Hunley, I have a plea form here that says you're going to plead guilty to counts 1 and 2. I'm going to hold the first page of this agreement up. It's 3 pages, and I'll show you the signature line next. But this is the first page. It has your name. It says plead guilty. It has the 2 charges there. You see that?
Yes, sir.
And you recognize that?
Yes, I do, sir.
All right, now page 3, about almost halfway down the page, there's a sentence that says, I enter this plea voluntarily. Immediately below that is a signature defendant and a signature that is very nice, actually, Tyler Hunley. And is that your signature there?
Yes, sir, it is.
When did you sign this document, Mr. Hunley?
Last week, Your Honor.
And when you signed it, did you understand it was an agreement to plead guilty, which means there's not going to be a trial? The next step in your case would be a sentencing hearing?
Yes, sir, I did.
And is this, before you signed it, did you go over it with your attorney and have her explain everything to you?
Yes, sir, she did.
All right, and did you feel that you had enough time to fully consider this matter before making this decision?
Yes, sir, I do.
And is this something you still want to go forward with? You haven't changed your mind?
No, sir, I do. I want to go forward with it.
All right, and you entered into the agreement to plead guilty voluntarily?
Yes, sir.
All right, now it states, as I said on page 1, that you're going to plead guilty to counts 1 and 2. Both of those are misuse of a credit card under 2913.21b2. The first count is a 5th degree felony. The second count is a 4th degree felony. And it states that you understand on page 1 that the maximum prison term possible for count 1 is 12 months, count 2 is 18 months. Minimum, if a prison term on each is imposed, is 6 months. There's a fine available of $2,500 in count 1 and $5,000 in count 2. If you're convicted of both of these offenses, the sentences could be served consecutively, which means you could have a potential maximum sentence of 30 months and a possible maximum fine of $7,500. You understand that?
Yes, sir, I do.
Are you facing any felony charges in any other jurisdiction?
No, sir, not at all.
Are you currently on probation, community control, parole, post-release control, or parole for any felony in the state?
No, sir.
All right, now, if you're convicted of these offenses and if you should be sentenced to prison, upon completion of that prison term, it is possible that the Adult Parole Authority, at their option, may choose to put you under post-release control supervision for a period of up to 2 years, which means you'd be supervised under the terms they set by a parole officer. And if during that period of time they determine that you had not complied, they could return you to prison, even though you served the entire term set by the court, for an additional period of up to 9 months for a single violation with a cap of half of your prison term for all violations. But if you commit a new felony, then in addition, whatever sentence the judge in the new case can impose upon you, that judge could also sentence you for committing that offense while under post-release control in this case to an additional period of a year or whatever time is left on that period of post-release control, whichever is greater. And if that occurred, that would have to be served consecutively to the sentence in the new case. You understand that?
Yes, I do, Your Honor.
Now, under the law, I'm not required to sentence you to prison for these offenses. I can impose what's called community control, which means that instead of going to prison, you'd be put under the supervision of a probation officer for a period of up to 5 years under terms set by the court. If during that period of time they felt you were not compliant, they would file a written notice of that with the court. There would be a hearing. You'd be entitled to have an attorney. If the outcome of that was that you'd failed to comply, then at that time the court could revoke your community control, sentence you to prison for 30 months, and fine you $7,500. Do you understand that?
Yes, sir, I do.
All right, now the first count in this indictment alleges that on or about the period beginning November 1, 2022, continuing through to November 10, 2022 in Highland County, Ohio, you did with purpose to defraud, obtain property or services by the use of a credit card in one or more transactions, knowing or having reasonable cause to believe the card has expired, been revoked, or was obtained, is retained, or is being used in violation of the law. The victim of said offense being an elderly person as defined in ORC Section 2913.01 and the credit card being used in a 90-day consecutive period, parenthesis, Chase Bank, violation of Section 2913.21b2. So that's the charge of misuse of credit card, the 5th-degree felony with a 6 to 12-month prison term possible and $2,500 fine. Count 2 alleges the same thing, except in the same time period. No, I'm sorry. It says beginning November 1, 2022, continuing through December 20, 2022 in Highland County, Ohio. But otherwise, it's the same language, except it also alleges that in that case, the value that was obtained was over $1,000, less than $7,500, and that refers to a Lowe's card. Otherwise, it's the same. And because of the amount involved, that would make it a 4th-degree felony with a prison term of 6 to 18 months and a fine of $5,000. Now, Mr. Hunley, do you understand what it is you've been charged with, what the state said you did, when, where, and how they alleged you did it?
Yes, sir, I do.
And have you discussed the nature of those charges, the evidence in the case, the possible legal issues in the case, possible defenses you might try to raise in trial, and the possible outcomes of trial with your attorney?
Yes, sir, I have.
And are you satisfied with her advice and competence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir, not at all.
Have any threats been made to get you to plead guilty here today?
No, sir, not at all.
On page 2, there are about 2.5 lines printed in bold and underlined that read as follows. Defense shall plead guilty to count 1 and count 2. State will dismiss count 3. State defense jointly recommend community control and star. Defendant agrees to make full restitution. Is that your understanding of the agreement?
Yes, sir.
Anyone promise you anything other than that to get you to plead guilty?
No, sir.
Mrs. Collins, do we know what the amount of restitution would be?
There's no restitution, Your Honor.
Okay.
The bank's covered everything, and I know you'll ask, we have been in contact with the victims. This case was initially filed in as a prelim, and they are actually Mr. Hunley's family, and they are very hopeful that he gets into the STAR program. Drugs have absolutely been an impact in his life in a big way.
Okay. Now, Mr. Hunley, under the law, the matter of sentence is up to the judge, not to the parties, and so even though there's that recommendation that you get community control if you plead guilty, I don't have to follow that. If, after I've heard all the information and evidence, I decide that's not the appropriate sentence under the law, I could sentence you to prison for between 6 and 30 months, fine you $7,500. You understand that?
Yes, sir, I do completely.
All right. Now, do you hold any license or certification from any state agency that regulates any occupation or profession?
No, sir, I do not.
Now, you have certain constitutional rights you must understand. First of all, you have right to counsel. Ms. Witt was appointed to represent you, not simply to work the case out, but to provide any defense that could be available to you under the law that you wish her to provide. So, if you decide you do not want to do this, she'll continue to represent you, including a trial, if that's what you want. You understand that?
Yes, sir, I do.
And forgive me if I've already asked this, but I've done this so many times today, I've lost track of what I've said in what case. But Ms. Witt, you and your client both agree to his appearance here remotely by Zoom rather than in-person appearance?
Yes, we do.
And you're all right with that, Mr. Hunley?
Yes, sir, I am.
And I didn't say this at the beginning, but if you need to talk with her, about anything, since you're not seated with her in the courtroom, just tell me and I can put the two of you in a breakout room where you two can talk without anyone else here seeing you, and the deputy would step out of the room, so your conversation would be private. Okay?
Okay.
All right. Now, under the Constitution, you have a right to have a jury trial in this matter, Mr. Hundley, in which 12 people will be selected from a group of citizens that live in Highland County that were summoned for jury duty on your trial date. After they were seated, the evidence would be presented, and they'd be instructed on the law by the court, and then that jury would decide by unanimous verdict, meaning that all 12 of them would have to agree on a verdict as to each of the charges. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive in writing, which means to give up your right to have a jury trial, and in that case, you would have what's called a court or bench trial. And that means that instead of a jury hearing the evidence, the judge would hear the evidence, the judge would apply the law, and the judge would decide whether or not the state proved your guilt. Do you understand that?
Yes, sir, I do.
Now, under the Constitution, you have a right to confront witnesses against you and to cross-examine them through your attorney. What that means is that witnesses against you have to come into court and testify in front of you and your attorney and anyone else is present. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination. The purpose of that is to try to bring out evidence that helps your side of the case. Do you understand that?
Yes, sir, I do.
Under the Constitution, Mr. Hundley, you have a privilege against self-incrimination, which means that you have a right to use the power of the court to compel or force witnesses to come to court to testify for you, just like the state. So if you had witnesses you're not certain would come in voluntarily, at your request, the court issues a court order, that's a subpoena, and that forces those people to come to court even though they don't want to be here, which is the same way the state's witnesses are forced to come to court to testify against you. Do you understand that?
Sure do. Yes, sir, Honor.
All right, now under the Constitution, Mr. Hundley, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't. The judge can. It's your decision if you decide not to testify. The fact that you did not testify cannot be used against you in any way by any person at any time, and no one's even allowed to comment about it, except in one situation. If there's a jury trial and you don't testify, the judge instructs the jury that because that's your right, they cannot consider it for any purpose. Do you understand that?
Yes, sir, I do.
All right, now, Mr. Hundley, under the Constitution, you're presumed innocent of these charges until proven guilty by the state of Ohio on every essential element of each offense. So what that means is that the burden of proof isn't on you to try to prove you're not guilty. The burden of proof is on the state to prove that you are. So you don't have to put on any evidence in your own defense at trial. You can, but you're not required to. But whether you do or not, the burden of proof will remain upon the state to prove your guilt by proof beyond a reasonable doubt on every essential element of the offense charged, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, sir.
Originally, you entered a plea of not guilty. Not guilty plea denied the allegation in the indictment, denied that you committed a crime, and it exercised or invoked all of the rights that I've just described. Now, if you change your plea from not guilty to guilty, that is the complete opposite of the not guilty plea. The guilty plea, the guilty plea admits allegations in each count, and the indictment admits that it's a crime and that you committed that crime. And that plea waives, gives up all the rights that I've just described for you today, except your right to have an attorney. You always have a right to have an attorney no matter what your plea. But with that exception, your plea of guilty waives or gives up your right to a jury or a court trial. Waives or gives up your right to confront witnesses against you and to cross-examine them through your attorney. Waives or gives up your right to use the power of the court to compel or force witnesses to come to court to testify on your behalf, the same as the state. It waives or gives up your privilege against self-incrimination, because if you say you're guilty, that's what's used to find you guilty. It waives or gives up your presumption of innocence, because if you say you're guilty, the state doesn't have to prove you're guilty. It subjects you to being sentenced immediately by the court. And finally, it waives or gives up any right to file an appeal you think you may have had up until this point in the case. Now, if I were to sentence you to the maximum sentence or under the certain circumstances you can file an appeal, that would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
Yes, sir, I do.
And are you a U.S. citizen?
Yes, sir.
Do you have any questions about the plea or about the charges or the possible penalties?
No, sir, I do not.
You understand those?
Yes, sir.
You have any questions about the plea agreement?
No, sir.
You understand it?
Yes, sir.
You have any questions about the constitutional rights I've explained?
No, sir.
You understand those?
Yes, sir.
Any questions about the plea of guilty, what it means, what will happen if you enter that plea?
No, sir.
You understand that?
Yes, sir.
You have any questions that you'd like to ask your attorney about before we go any further?
No, sir. She was clear on everything at our meeting.
All right. Then is there any? Then is it your decision to withdraw your not guilty plea, plead guilty to counts 1 and 2, pursuant to the terms of this agreement? Is that your decision to plead guilty?
Yes, sir.
All right, then, as to count one, which alleges on or about the period beginning November 1, 2022, continuing through November 10, 2022 in Highland County, Ohio, you did with purpose to defraud, obtain property or services by use of a credit card in one or more transactions, knowing or have reasonable cause to believe the card has expired or been revoked or was obtained, is retained, or is being used in violation of the law. The victim of said offense being an elderly person as defined in ORC Section 2913.01, and the credit card being used in a 90-day consecutive period. Chase Bank Card 2913.21B2 of the Higher Revised Code is the violation, a fifth-degree felony, carrying possible prison term 6 to 12 months, and fine of $2,500. How do you plead?
Guilty, sir.
As to count two, which alleges on or about the period beginning November 1, 2022, continuing through December 20, 2022 in Highland County, Ohio, you did with purpose to defraud, obtain property or services by use of a credit card in one or more transactions, knowing or have reasonable cause to believe the card has expired, been revoked, or was obtained, is retained, or is being used in violation of the law. The victim of said offense being an elderly person as defined in ORC 2913.01, and the credit card being used in a 90-day consecutive period, the value of loss being equal to or exceeding $1,000 but less than $7,500. The Lowe's card, in violation of Section 2913.21B of the Higher Revised Code, also misuse of a credit card, a fourth-degree felony, with possible prison term 6 to 18 months, fine of $5,000. How do you plead?
Guilty, Your Honor.
All right, thank you. The court finds on this day in open court, defendants advised of all his constitutional rights made no intelligent voluntary way of the same pursuant to Rule 11. Please accept the order of file. Defense found guilty of counts 1 and 2 as set forth therein. Count 3 is dismissed. Matters referred to the probation department for pre-sentence investigation, include assessment for substance use and mental health issues. Sentencing hearing will be May the 3rd at 9 a.m. Bond will be continued. And the court will also refer this to the drug court docket for review. All right. Anything further, counsel?
Yes, Your Honor.
All right. Thank you.
Oh,
We have other things, Judge.
Pardon me?
You said, is there anything else? And everybody said yes, and you said, okay, thank you.
Oh, okay. I'm so used to you not saying anything, I guess I wasn't thinking. So, all right. What is it?
The one thing I was going to say is I'm not sure that he's eligible for drug court because I thought you had a prior felony.
No.
Oh. Okay.
Depends on the ORAS score. So
Okay.
the more felonies, the higher the score, but it's not it's a combination of that as well as past treatment and past drug abuse and a whole bunch of other things. Yeah.
Okay. And Ms. Rass or Ms. Witt?
Your Honor, if he does get a star bed, would you allow him to be furloughed to star before the sentencing
He
date?
can't go to STAR until he's sentenced.
Okay.
Yeah. There has to be a sentence to STAR because it's a CDCF.
Okay.
Yeah.
Okay.
Okay. Thank you. All right. State of Ohio versus Tristan M. Nelson. This is a hearing, pretrial hearing being conducted by Zoom. Mr. Nelson's appearing from the probation department. Attorney is Danielle Witt, appearing from on her phone by Zoom. Appearing from the prosecutor's office, prosecuting Attorney Collins. Defendant's charged along with Jaden Florence with theft, breaking, entering, and receiving stolen property, and then also he has receiving stolen property in count 4. That's the first pretrial. Final pretrial set May 3. Trial set for June 12. I see the state's provided the bill of particulars and discovery, and you've received that, Ms. Witt?
Yes, I have.
All right. Your discovery will be due by the final pretrial. I don't see it in the file. You haven't filed it yet, have you?
No.
All right. Do you anticipate any pretrial motions?
No, none at this time.
All right. If there are any, they're due by the final pretrial. And do you have you received a written plea offer?
I have.
Is your client aware?
No, I need to get a contact number for him.
All right. You want to give her a number she can get in touch with you to get an appointment to discuss this, Mr. Nelson?
Yeah.
Go ahead.
Okay, what's your...
937-500-9957 if Can I give you another number? Is it okay if I use my phone real quick?
Yeah, go ahead.
Okay, thank you. The other number is 937-205-7485.
7485?
Yes, ma'am.
Okay, thanks.
All right, thank you. All right, you go ahead and sign out then and go, Mr. Nelson.
Thank you.
All right, are you? Versus Jessica A. Brown. This is a final pretrial being conducted by Zoom. Ms. Brown's appearing from the Justice Center as indicated. Her attorney is Danielle Witt, appearing on her phone, appearing on behalf of the state's Prosecutor Collins from the prosecutor's office. Defendant is charged with aggravated possession of methamphetamine. This is a final pretrial trial set on April 27. I have been presented with a plea of guilty form, Ms. Brown. Before I go forward, I want to ask Ms. Witt, you and your client both stipulate to her appearing by Zoom rather than in person in the courtroom?
Yes, we do.
You're all right with that, Ms. Brown?
Yes.
All right, the plea of guilty form here is 3 pages. On the first page, it says you're going to plead guilty, and it has your name, case number. I'm going to hold that up to the camera and ask you if you recognize that form there.
Yes, sir.
All right, on page 3, there are signature lines. About a third of the way down, there's a sentence that states, I enter this plea voluntarily. Immediately below that is a signature of Jessica Brown. And I'll ask, hold that up to the camera and ask if that is your
Yes,
sentence
sir.
or your signature.
Yep.
And when did you sign this agreement?
2 days ago.
And before you signed it, did you go over this with your attorney and have her explain everything to you?
Yes.
And did you understand it's an agreement to plead guilty, which means there's not going to be a trial, and the next step in your case will be a sentencing hearing?
Yes.
And do you think you had enough time to fully consider this matter before making this decision?
Yes, sir.
Is it your desire to go forward with that today, even after a few days have passed?
Yes, sir.
And are you entering into this agreement to plead guilty, and are you pleading guilty today voluntarily?
Yes.
All right, on page 1, it says you're going to withdraw your not guilty plea, plead guilty to the charge. Under 2925.11, the Higher Revised Code, aggravated possession of methamphetamine, 5th degree felony. Further states you understand that the maximum penalty for that could be 12 months in prison. If prison is imposed, the minimum would be 6 months. Could be a fine of $2,500, and there could be a license suspension of 6 months to 5 years. Do you understand that?
Yes, sir.
And are you facing any felony charges anywhere else?
I don't know. I might have a possession coming up in Clinton County that I caught before this one.
All right. Well, if you are convicted in both counties, and if you should be sentenced to both counties to prison, those sentences can be ordered to be served consecutively, meaning one after another. Do you understand that?
Okay. Yeah.
All right. Now, you're not currently on probation, parole, community control, or post-release control from any county?
No.
All right. Under the law, if you should be convicted and sentenced at any time on this offense to prison, upon completing that term, it is possible that all parole authority would exercise its right under the sentencing law to put you under post-release control supervision for a period of up to 2 years. If they do, you'll be supervised by a parole officer on the terms they set, and if during that period of time they determine that you have not complied, they can return you to prison and make you serve an additional period of up to 9 months for a single violation. Well, in this case, the maximum is half of your prison term, so the maximum would be 12 months. So there would be a cap of half of whatever prison term there was for all violations. But if you can commit a new felony, then in addition, whatever sentence could be imposed for that new felony by that judge could also sentence you for committing that offense while under post-release control, in this case, to an additional period of a year, whatever time is left on that period of post-release control, whichever is greater. If that occurred, that would have to be served consecutively to the sentence in a new case. You understand that?
Yes, sir.
Under the law, I'm not required to sentence you to prison for this offense. I can impose what's called community control or probation, which means that instead of going to prison, you'll be put under the supervision of a probation officer for a period of up to 5 years under terms set by the court. If during that period of time the court or the probation department felt that you were not compliant, they could file a written notice of that with the court, serve a copy on you. There would be a hearing, and you'd be entitled to have an attorney. The outcome of that hearing was that you had failed to comply, then at that time the court could revoke your community control and then sentence you to prison for 12 months, fine you $2,500. Do you understand that?
Yes, sir.
All right, now, the charge in this case alleges that on or about March 18, 2022 in Highland County, Ohio, you did knowingly obtain, possess, or use a Schedule II controlled substance, to wit methamphetamine, in violation of Section 2925.11 of the Higher Revised Code. So that is the charge that we've talked about here. Do you understand what it is you've been charged with, what the state said you did, when, where, and how they alleged you did it?
Yes, sir.
And you understand the possible penalties?
Yes.
Have you discussed the nature of that charge, the evidence in the case, possible legal issues in the case, possible offenses you might try to raise at trial, and the possible outcomes of a trial with your attorney?
Yeah.
Are you satisfied with her advice and competence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Has anyone threatened you to get you to plead guilty here today?
No.
Now, on page 2, there are 2 lines which read, defendant shall enter a plea of guilty to the indictment, state and defense jointly recommend community control, and defendant be referred to drug court. Is that your understanding of the agreement?
Yes, sir.
Anyone promise you anything other than that to get you to plead guilty here today?
No.
Now, under the law, the matter of sentence is up to the judge, so, you know, just because it's been agreed to by the parties doesn't mean it has to be followed if you plead guilty. If you plead guilty, once I've heard all the information presented, if I find that's not the correct sentence under the facts of the law, that could be, I could end up sentencing you to prison for a period of between 6 to 12 months and fining you. You understand that?
Yes, sir.
All right, now, do you hold any license or certification from any state governmental agency that regulates any occupation or profession?
No.
Now, you have certain rights you must understand before I can accept your plea. First, you have a right to have counsel. Ms. Witt was appointed to represent you not simply to work the case out, but to provide any defense that might be available to you under the law that you would like her to provide. So if you decide you do not want to do this, that you'd rather defend against the charge, she'll continue to represent you and defend you, including a trial if that's what you want. Do you understand that?
Yes, sir.
Now, under the Constitution, you have a right to have a jury trial in this matter in which 12 people would be selected from a group of people that live in this county, summons for jury duty on your trial date. After they are selected, the evidence will be presented, they'd be instructed on the law by the judge. They would then decide, by unanimous verdict, meaning all 12 of them would have to agree, as to whether the state proves your guilt. Now, if you didn't want to have a jury trial, but you did want to plead guilty, you can waive in writing, which means to give up, your right to have a jury trial, and in that case, you would have what's called a quarter bench trial. And that means instead of a jury hearing the evidence, it would be the judge who would hear the evidence, apply the law, and decide whether or not the state proved your guilt. Do you understand that?
Yes.
Right now, under the Constitution, you have a right to confront witnesses against you in open court and to cross-examine them through your attorney. What that means is that the witnesses against you have to come into court and testify in front of you and your attorney and anyone else present. After the prosecutor's done asking questions, your attorney asks questions, that's cross-examination, the purpose of which is to bring out evidence that helps your side of the case. Do you understand that?
Yes, sir.
Under the Constitution, you have a right to use the power of this court to compel or force witnesses to come into court to testify on your behalf, the same as the state. So if you have witnesses you're not certain are going to come in voluntarily, at your request, the court issues a court order called a subpoena, and that forces those witnesses to come to court to be available to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are forced to come to court to testify against you. Do you understand that?
Yes.
Right now, under the Constitution, you have a right or a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including the trial. So no one can ever make you testify. The prosecutor can't, the judge can, it's your decision. If you decide not to testify, that decision cannot be used against you in any way by any person, and no one's even allowed to comment about it, except in one situation. If there's a jury trial and you don't testify, the judge instructs the jury that because that's your right, they cannot consider it for any purpose. Do you understand that?
Yeah.
Right now, under the Constitution, you are presumed innocent until proven guilty by the state of Ohio on every essential element of the offense charge. What that means is the burden isn't on you to try to show you're not guilty, simply because you've been accused. In fact, under the law, you don't have to put on any defense at trial. You may, but you're not required to. But whether you do or not, burden of proof will remain upon the state to prove your guilt or proof beyond a reasonable doubt on every essential element of the offense charge, which is the highest burden of proof that's known under the law. Do you understand that?
Yeah.
All right, now, originally entered plea of not guilty, which denied the allegation in the indictment, denied you committed any crime, and exercised all the rights I've just described. If you change that plea from not guilty to guilty, that's the opposite of the not guilty plea. The guilty plea admits the allegation in the indictment, admits that it's a crime, that you committed that crime. That plea would waive or give up all the rights that I've just described for you, except your right to have a jury trial, a right to have an attorney. You always have a right to have an attorney no matter what your plea. But with that exception, your plea of guilty, wage gives up your right to a jury or court trial. Wage gives up your right to confront witnesses and cross-examine them through your attorney in open court. Wage gives up your right to use the power of the court to compel or force witnesses to be in court to testify on your behalf, the same as the state. Wage gives up your privilege against self-incrimination because you're the one saying you're guilty. That's what you use to find you're guilty. And it wage gives up your presumption of innocence because if you say you're guilty, the state doesn't have to prove you're guilty. It subjects you to being sentenced immediately by the court. And finally, it wage gives up any right to file an appeal you think you may have had up until this point in the case. Now, if I sentence you the maximum sentence, or under other certain circumstances, you could file an appeal, but that would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
Yes, sir. I understand.
I couldn't hear you.
Yes, I understand.
Okay. And you are a U.S. citizen?
Yes.
Do you have any questions about the charge and the possible penalties?
No.
You understand it?
Yeah.
Any questions about the plea agreement?
No.
You understand it?
Yes.
You understand that the recommendation on sentencing is not binding on the court?
Yeah.
Any questions about the the constitutional rights I've explained to you regarding the plea?
No.
You understand it?
Yeah.
Have any questions about the plea of guilty, what it means, or what the consequences of that will be if you enter it here today?
No.
You understand?
Yeah.
Is there anything you'd like to speak with your attorney about before we go any further?
No.
All right, then is it your decision to withdraw your not guilty plea and plead guilty to the charge according to the terms of this plea agreement?
Yes, sir.
And as to the charge, which alleges on or about March 18, 2022 in Highland County, Ohio, you did knowingly obtain, possess, or use a Schedule II controlled substance, to wit methamphetamine, in violation of Section 25.11 of the Ohio Revised Code, a charge of aggravated possession of methamphetamine, a fifth-degree felony. How do you plead?
I plead guilty, Your Honor.
Right. And I don't know if I said this at the beginning, but Ms. Witt, you and your client are both in agreement that this hearing be conducted by Zoom rather than in-person appearance?
Yes, we are.
And you're all right with that, Ms. Brown?
Yeah.
All right.
Yes.
All right, the court will find on this date, open court, defendant is advised of all of her constitutional rights, made no intelligent voluntary waiver of the same pursuant to Rule 11. Please accept an order filed. Defendant is found guilty of the charge as set forth in the indictment. The matter is referred for a pre-sentence investigation, which will include an assessment for substance use and or mental health issues. Case is also referred to the drug court. Oh, wait a minute. Yeah, referred to the drug court for review. And the sentencing will be May the 3rd at 9 a.m. Bond will be continued. Now, anything further from counsel?
I was under the impression that I was being OR to the facility. I'm not being OR to the facility.
Hold on.
Oh.
No, you're not, because we don't know where, we don't have a bed for you, and there'll have to be a motion filed for that, if there is a bed available.
Your Honor.
Pardon me?
We have a bed.
Okay, well, I'm not aware of that. When's the bed available, Ms. Sturgill?
May 3rd, or I'm sorry.
Monday.
Yeah.
Monday, sir, with the Recovery Council.
April 10?
Yes.
All right. Then you can be released on your OR on April 10 to Recovery Council, Ms. Brown. Now, you need to understand this. The condition of that OR bond, in addition to everything else that I said, is you have to stay there. You can't walk away. Don't talk.
I'm not
listen.
taking a chance.
Don't talk. Listen.
Oh, I'm sorry.
Can't hear when you're talking. So, again, if you don't stay there and you walk away, you'll be in violation of your OR bond. And that will mean that it's highly unlikely you're going to get treatment. You'll end up going to prison most likely because you do have some record here. And so you need to understand that. So if you decide you don't want to go there, you don't want to stay there, then you need to call the probation department and they bring you back to jail. Okay? You understand?
Yes.
All right. So bond is modified to OR only, effective April 10, on condition defendant goes to and remains at, did you say the Recovery Council? All right, TRC, until sentencing. All right, anything further?
No, Your Honor.
Thank you, Your Honor.
Thank you. I believe that completes the docket.
I'm done.